very many cases. Very good cases would be lost on account of the fact that there was no investigation. And I believe this matter, it is so important that recently, when there was some interviews to pick the successor of the good Justice Muhammad Ibrahim, I believe, one of the candidates, Court of Appeal Judge Francis Tuyot, is captured by the Star newspaper. This appears at paragraph 86 of our submissions, where he was being asked about these matters to do with investigation and why and how it leads to many cases being challenged. Let me quote the judge. I don't want to summarize in the wrong way. He said as follows: the court cannot fill the gaps left by the investigator. If the investigation is defective, the case must fall, because the burden of proof is always on the prosecution. We often see cases where the chain of custody is broken or where forensic evidence is not properly collected. These are not just mistakes. They are a pattern that suggests we need deeper institutional reform in our investigative agencies. It is better for a guilty person to go free than for a court to convict based on defective and hollow investigation. Our duty is to the law and the constitutions, not to public clamor. The pressure of time must not be used as an excuse for a shallow judgment. The public must see that even in those 14 days, the court applied its mind to the critical grievance brought by the petitioners. So that, my Lord, the learned appellate judge was saying of something, a basic requirement of our constitutions, that investigations of crimes is important, because it is through investigation that you are able to tell the truth from lies. It is through investigation that an opportunity is accorded to the accused to point out that, consider this evidence, it does not show that I was guilty. So that your lordship's confronted with a situation where a constitution has said and has provided for a mechanism to ensure there is investigation. The Senate acts as if this is a matter of political discretion. You should be scandalized. The conscience of the court should object to this. And that objections must result that this thing has to die. Justice was not done. Justice was not done in the manner of impartial justice required in a constitutional democracy. I need to explain this further. My Lord, there was this important case of Kinoti and others versus Chief Magistrate's Court, a decision of Judge Mrima. Kinoti, I must say, is my partner in my law firm. And this case is important for a couple of reasons. It's a long judgment when you read it. But I quote these decisions from paragraph 87 to 88 in order for three major reasons. The first issue is that it cites several decisions that underscores the necessity of investigation as part of the procedure of administration of justice, particularly in all kinds of justice. Because even before a normal tribunal, there must be fair administration of justice. Because unless you want to have a case of Jesus Christ of Nazareth, if one were to be confronted by a situation where a court system doesn't care whether the allegations are true or not, then that would not be a court in any manner that one would understand it in a democracy, leave alone a constitutional democracy. So that it is those investigations that you care about the truth. Caring about the truth is what can be able to validate our commitment to do justice. So that, my Lord, what we are saying is this. Truth became discretional before the Senate. Truth cannot be discretional before the High Court, because its full name is the High Court of Justice. We go to an important decision that was decided very many years ago. I believe it was in the year 2003, and that is the celebrated case of Juma and others versus Attorney General. This is a case, even when you go to committee, remandees knows it. They know the right to be availed statements and the evidence of the prosecution. This decision is important for that reason. It is later on find its better expression in Article 50 of the Constitution. But to the credit of the High Court, that very important decision was made when we did not have a good constitution like we have today. And these decisions, my Lord, was saying an important, crucial issue. It says that about the elementary system of justice is one that is justice that is based on investigation, a caring for the truth. What actually happened? Is this man guilty, as the people demanding his blood are saying? That must be the concern of the High Court. It ought to have been the concern of the Senate. Tragically, it was not. Remedy must now come to ensure that is done. And the importance of that decision of Juma, why I'm quoting it today, is that it refers, I believe it was by Judge Kuloba and Justice Mpogoli Msaga. It talked about the value of the adversary justice system and what it connotes. You do not read anywhere in our Constitution any description what the adversary system of justice is, but you see features of it embodied in our constitutions. My Lord, the adversary justice system is a procedure in which truth must be founded on those who say this man is guilty have an opportunity to say their piece. Those people who are saying this man is not guilty must have also the opportunity to say that he's not guilty. And at the end of the day, the judge, listening to the partisan speeches, to the partisan position of presentation of evidence, makes a decision on the basis of interrogation of facts and evidence, on the basis of a determinations to inquire into the truth, so that it is a commitment to seek justice through a certain methodology. It is our submissions, my Lord, that justice before the Senate necessarily had to fail, not only because there was no modification, but when senators decided this is a matter of discretion. You cannot. Many cases like we've read from the learned judges of the Court of Appeal, many cases fail because investigations were defective. The case before you is a case of no investigation. My Lord, I repeat that. Because if you are to have, under the 2010 Constitution, a situation whereby there is a judgment of the High Court saying that justice is done with zero investigation, ordered by the Constitution is okay, one would wonder, why was the fight about? Why did we need to have a new constitution? My Lord, I am absolutely sure that we shall not reach there, and that is why we have tried to be able to demonstrate that that is indeed the case. My Lord, it is also important that we speak about something about the Senate and the structure of impeachment proceedings. My Lord, in the US, that's where impeachment came from. Even here, there was a bit of that I saw. Those people who had the House managers, the people from the National Assembly, who had said we have impeached this man, were given an opportunity to present their case. There was also supposed to be a procedure where Rigathi Gachagua and his team would also be given their piece. The senators, as understood in the US, and as we saw during the impeachment of President Clinton, are jurors. They make the decision. You listen to how the cases have been presented, how the defense has been made. Then in good conscience and in fidelity to the oath of office, you decide, is this man guilty or is not guilty? There was a tragic failure by the speakers, it appears, not to have properly guided the senators. It's for a good reason that lawyers are ordinary speakers in Kenya. It should count for something. It appears not to have counted in this matter. But what's the point that we are saying? In the US, before the Senate, when they say the judge, the Chief Justice, is going to preside over the impeachment of the president, it is because ultimately he is the custodian of justice, of fair procedure, to ensure that these politicians, before they vote, they have been guided with the evidence, fair hearing procedures have been availed to the parties, and everybody has ventilated their case. Now, before the Senate, we had this issue, and some of my learned colleagues have already argued. There is no time limitations. And it is illogical why there ought not to be time limitation. If somebody says I need an hour or two to properly prepare my case or to defend myself, that ought to be given in the ordinary course of things. Before the Senate and before the National Assembly, we've had politicians, they have had difficulties in giving a fair opportunity for people to ventilate their cases, even when the consequences are very dire. In the US, it took a month. Justice Rehnquist presiding over the impeachment proceedings of Clinton. In the US, no provision is given. How much time do you take? The Kenyan constitutions, when you go to the latter part of the constitution after the report has been submitted, there is no timelines that are given. It's an opportunity that is supposed to be given to the now the full plenary and to both sides to be able to present their case. So that, my Lord, if that did not happen, and there was an obsession with the time, you must take 1 hour, you must take 2 hours before an important issue could be resolved before the senators, that was where the tragedy of justice occurred in this matter. And that also, my lords, it must be connected to two important issues before I forget them. Under Article 145 of the Constitutions, the President and the Deputy President, they have two rights of hearing, expressly set out. The right to be heard before the investigating committee, the special committee, and the right to be heard by the Senate, the plenary of the Senate. Those are two independent rights to be heard. None is a substitute for the other. Those two rights cannot be collapsed because they don't serve the same purpose. My lords, even in all our trials, even in criminal proceedings, and we have discovery in civil proceedings, you have two rights. When an accusation is made by the complainant, justice will not be done unless the police also called you to require you to give a statement, to give you a side of the story. That's the first right. This right, in our submissions, is a right that ought to have taken place before an investigator appointed by the Constitution, the special committee. The second right is a second right to be heard by the person who will make the decisions of guilt or innocence. that was supposed to be the senators. The senators did not, at the end of the day, of course, have to have a serious right to be heard. But the more important point that I need to point out at this stage is this, that, my lords, under the Constitution of Kenya, you cannot be an investigator, a complainant, and a judge. That had been done by the DPP was nullified by the High Court on the ground that it purported to collapse those three roles to some officers appointed by KRA. So that if in the normal course of things, the High Court protects ordinary people charged with regular offenses, that you cannot, your due process rights cannot be taken away. It is all the more important, my lord, that that also be accorded to the first petitioner, unless there is any good reason that, and there is a principle of law that says no man is too high or too low to be unworthy of the protection of our constitutions. My lords, I urge that fundamental failure of justice is inexcusable and can only lead to one decision. There was no proper vote for the impeachment of the first petitioner. That, of course, goes with the issue of saying, and now that is the next issue, on whether the first respondent, the first petitioner is a subject or is a victim of a political conspiracy. My lord, it is important to point out that, because this is where my clients are very much interested in, that under Article 75 of the Constitution, when a person has been removed from office, 75(3), that person is disqualified from holding any other political office. My lords, the first petitioner is interested and is also a political office, is a politician, and politics is a transaction between leader and people, right? As it were. We are here because I represent members of his constituency. And because of that particular reason, it is why the petitioners I represent would be very careful about the prospect
reason your father said that.
I wonder what you being barred from contestations of the political office on account on an extremely tragic and effective impeachment. Why does this matter? And where is the entry point? My lord, we have Article 1 of the Constitution. Sovereignty vests in the people. We have Article 38 of the Constitutions, the issues of political rights. The Supreme Court has said, adopting a certain memorandum on standards of impeachment, basically saying that impeachment proceedings must be carried out in a manner that ensures those fights that should be resolved by the people through normal democratic elections are actually solved by the people. So that the right to form government is a right to govern together. That is what Ben Wabweze told us in very many books that most of us quote times without number. The right to get power is a right to govern together. We have annexed the Memorandum of Kenya Kwanza. We have annexed UDA. UDA itself was an alliance that all said what after getting power we were supposed to do together. There was a breach of that democratic contract. That is not just a breach between the first petitioner and the sixth respondent. It is also a breach between the constituency that expected certain representations by its consciously appointed or selected leaders would partake in the governance of the country. Your Lordships, this matters because elections matters in a democracy. But my Lord, the High Court, as a guardian of the constitutions, cannot countenance a situation that in 2027, when we shall be doing an elections, if I figure out that Paul Muite is a very popular leader and he should seek power together with me, in a democracy, the mandate you get from the people is that you will govern for 5 years with Paul Muite. But my Lord, if it turns out that Paul Muite gets you to get to the office, and then 2 years, 1 year down the line, you want to remove Paul Muite and replace him with another person, two obvious questions would have arisen. And that question is, why did we have to go to the elections? We go to the elections in order to get the political elite that will be responsible for our statecraft for 5 years. But it turns out, my lords, that there is any single person alone or in conspiracy with others who can be able to change the nature of the democratic mandate obtained through an election. That would be a grave violation of democracy as ordinarily understood, but more importantly, of constitutional democracy in our country, because the constitution of our country, I think the Article 3(2) says it is unlawful to establish government otherwise than in accordance with the constitutions. In Kenya, government is established pursuant to an elections. It is therefore, my Lord, our submissions that a scenario in which the very foundations of our democracy is contested, becomes disputed, that state of affairs cannot be permitted. Recently, in the case of Governor Guyo, a 3-judge decisions of the High Court explained, we have quoted it somewhere, explained at length that the nature of our constitutional democracy is that you must respect the people. The people appoints you in this party, gives you a mandate to govern with this manifesto. That must be respected. Because if it doesn't, democracy fails in the most fundamental sense, that it ceases to be a transaction where government, in the words of Abraham Lincoln, is a government of the people, for the people, and that is supposed to serve their purposes. So that, my lords, for purposes that happened, water under the bridge. The first petitioner said, I no longer want the office. That right must be respected. But what is important is this. Still on account of the same impeachment, if there can be no lawful government in my reading, in the reading of the petitioners I represent, between the impeachment of the first petitioner and the next general elections, it is important that the government that comes to office in Kenya in September 2027 will be a government established in accordance with the constitutions of Kenya. How do you get that government? That is the entry point. How you get that government is to ensure power is contested by everybody eligible on account of the constitutions of Kenya, without limitations imposed politically in order to secure political advantages. The case of conflict management, the ICC case, what was it all about? William Ruto and Uhuru Kenyatta are having ICC charges. They are not eligible to vote. The High Court decided many things. Some of the 3 that are important, that I wish to highlight, that he decided are: number 1, that The issue of who governs Kenya with a written constitution is a decision that belongs to the people. The people are the best suited to decide on that issue. Issue number 2 that you get from that decision is that given the history of our Kenyan nation, we had situations, you had it in 1969, you invoke a rule of procedure to get all candidates of Jaramogi's party debarred from contesting office. You had a situations whereby you could say that the day of nominations are 2 hours. Then you abduct your opponent. Your opponent does not submit their papers. Those are the kind of things that, in retrospect, the High Court in that case was saying are not permitted under the constitutions. That Article 38, the right to seek public office and to be voted, mean exactly that, and must be respected and cannot be derogated without justification. Issue number 3 from that case was this. It was the fact that, and that was for TNA. TNA had nominated William Ruto and Uhuru Kenyatta for their ticket for that year. And I represented TNA in that case. The right for TNA and its members to have William Ruto and Uhuru Kenyatta contest the elections was upheld on the ground that politics means nothing if the leader that best expresses your political aspirations in politics can just be disqualified, can just end up not being a candidate. So they upheld that right and said, for that right to be taken away in Kenya, very onerous standards would be required. In the case before you, my Lord, that onerous standards would be this. I'm about to finish.
Please.
Yes. That onerous standards would be this, that we have actually confirmed that there was a good impeachment. There was no malice. That we had a good parliament that could do the job. But what are we facing, my lords, before you? The scenario that we are facing is that we used to have the 6th parliament. The parliament that we had between 1988, the 6th, 1988 and 1992. It is a parliament that got rid of Dr. Karanja from his office in the manner that was described properly. Now, we also have the 13th parliament. We have its record of impeachment. I thank the lawyers for Parliament for giving us the full answered reports. You read them. If you are with foreigners, we have read impeachment proceedings in other countries. I wonder how proud one would be to say, these are Parliament. But that's not the important point. The important point is this, and we have the headquarters of Sifuna. Before somebody can be able to say that we do our job, we honor the constitutions. Constitution says Parliament be independent. It says protect the interest of the people. We have on record in our headquarters Senator Sifuna saying that he had observed, he said that in an interview with Cyrus Jirongo. He said that he observed that when the issue of the reductions of money to counties was taken to the Senate, he found it odd that senators voted against their counties getting more money. Yet the Constitution says you are in Parliament to protect the interest of counties. My brother, friend Degwajiro, has shown and stipulated in his submissions what people are saying during the time when they ought this or the other one to be done. We had in June 2024 a scenario whereby there is a national clamor saying this budget is bad. But it had to take an invasion of parliament for these same members of parliament to change their mind and to turn around and say, oh, it was a bad bill. What's the point we are saying? The point we are saying is a simple one. Before you say a good impeachment was passed, one must take a verdict of some kind and say, what kind of parliament is this? If a parliament looks like the 6th parliament, and we know all that used to happen during its time, then that cannot be a good parliament that will decide matters of life and death in the good constitutions of Kenya, and that can very easily attract our constitutional order. The final point, so that Mr. Kamaru can say his bit, is this, that there is an important issue, that an important right. I don't know whether there is a smaller section than that, but I like Article 28 of the Constitutions, the right to human dignity. That right to human dignity is actually a very brief provision. It says every person has inherent dignity and the right to have that dignity respected and protected. What does that mean on a day-to-day nature of things? What that provision means as applied in the context of this matter would be to say that in a country that Article 24 says we should be civilized and we should respect fundamental rights, if somebody says, I'm sick, and can I be heard on another day? That unless there is a very serious and express and explicit prohibition by the law, in a civilized society, you would have honorable senators and speaker permitting such a person to be heard on another day. It is something all of us lawyers, we know every day. In fact, it is only a very few lawyers, one judge had to ask, counsel, can you object? Your friend has said he is sick. You want us to proceed when he's sick? It is one basic courtesy because it rises from human dignity. There is a decision a while back that, this is the last point, a decision of Daniel Ogwaka Manduku and versus DPP, a decision by Judge Ogola that spoke something about the right to human dignity. I've read that decision. When I read that decision, it didn't appear like the judge was convinced that the petition had been filed properly. But at the end of the day, I saw the judge giving anticipatory bond. And why did he give anticipatory circumstances? He premised that on the right to human dignity. He said as follows, I don't want to quote him wrong. The purpose of bond or bail is therefore meant to treat suspected offenders with some measure of dignity. This dignity should be accorded to every citizen or suspect. The petitioner here prays for a bond or bail pending arrest that should that happen. Arrest in Kenya, this is an important part. Arrest in Kenya has become a public spectre. And I should think the prospect of being arrested is the most devastating emotional issue for the would-be suspected criminals, more so if they hold high office. In Kenya today, the public waits with bated breath whenever a senior public servant is rumored to be required for arrest. In a primitive society, very important, that would be the day when villagers met at a public square to witness public execution of public offenders. It, however, needs not be so. Every Kenyan should be arrested with dignity and be given a reasonable chance to apply for bail, either before or immediately upon arrest. Whilst at this, I found out that the risks of arrest against the petitioner are speculative, and the petitioner would still be given rights. At the end of the day, the importance of the case is that that bond that was being requested was granted to avoid a situation where the right to human dignity would be violated. In this particular manner, at that time I was watching from television the proceedings before the Senate when Paul Muite applied for adjournment on account of sickness. That was not granted. I remember one of my daughters, I believe this was Sheba Waidera, asking, why was that right not given? I was angry. I told him, these senators are biased. That's the only answer I could give. After some reflections, I told her, I think when this matter, I am aware impeachment goes to the High Court. I think when this matter goes to the High Court, we shall tell the High Court that was wrong. Mr. Kamwaro.
Thank you. Thank you very much. How much time did you ask?
30 minutes, but I'll try to finalize in 25 or less.
We'll give you 20 minutes.
Most of that. My lords, my name is Martin Olekamwaro. I need not to go deep into what my learned senior has done. But let me say this, that on behalf of the petitioners that we represent, the petition raises what the petitioner characterizes as a textbook parliamentary coup, the impeachment of His Excellency Rigathi Gachagua, the first petitioner as the Deputy President of the Republic of Kenya on 17th October 2024. My lady and my lords, I will try to summarize so that the others can also utilize judicial time. We have made a quote in our submission of Frederick Bastard that speaks with striking precision to this case, that when plunder becomes a way of life, a legal system is fashioned to authorize it. My lords and my lady, this is not, in truth, a case about impeachment. It is about the use of constitutional process to legitimize a predetermined political outcome. The charges that face the first respondent, particularly anchored on crimes under National Cohesion and Integration Act, Section 1310A and 62 of that act, on the issues of ethnicity or issue of the so-called shareholding. But the record reveals a profound inversion, that those who are alleging that he uttered words of ethnicity or tribalism are themselves operating within it and benefiting from the very logic they purport to condemn. Our submissions, my lords and my lady, demonstrate the issue was advanced in a manner steeped in institutional hypocrisy. Parliament was weaponized. The impeachment that shocked our republic. My lords and my lady, we need to handle this matter with clear minds. Ethnicity in this country and tribalism has acquired a dangerous mutation. Those who practice it most aggressively are those often its loudest accusers. Evidence is not in rhetoric. It is in appointments, in access to offices and corridors of power, and the quiet architecture of state power. We see, my lords, patterns in public office become a gateway for ethnic favorism, in which the first petitioner is accused of, where proximity to power translates to disproportionate advantage into public appointments. If you take an example of the community where I come from, as you compare with similar numbers in the Republic of Kenya, you will realize that somebody from a community can actually hang himself or herself considering the appointment that the community is allocated, for example. But that's for another forum. Yet when it comes to political expedient, the same actors, the real tribalists, turn out, accuse others, and claim moral authority. Who then are the real persons practicing ethnicity and tribalism in our country? Is it the one who is wrongly accused, the first petitioner in this case, or those who convert the instrument of state into pipelines for tribal patronage? My lords and my lady, the accusation is easy. Consistency of conduct is a true constitutional test before you. And on that test, it is the first petitioner who stands exposed. It is also his accusers. My lord, Article 150 creates a constitutional safeguard and not a political weapon. It demands, one, proof of the accusations leveled against you. Two, the threshold that must be met as per our Constitution. And three, fidelity to the due process, which my learned friends who spoke before me have highlighted. Then what then occurred in the National Assembly and the Senate? Number one, a political fallout recast as constitutional violation. Number two, a process driven by alignment, not evidence. You have heard many of them say, we have the numbers. The Constitution does not envisage that situation. Impeachment, as is prescribed by the Constitution, is not we have the numbers, so mutadu. A charge sustained by narrative, not proof. My lord, the issue is not whether the tribalism is undesirable. This is what it is. Can unproven allegation advanced by those who are themselves embedded in the worst kind of tribalism to be visited upon Kenyans satisfy the constitutional threshold removal? My lord, if the answer is yes, then impeachment becomes, one, a tool of convenience, a mechanism of political sanitation, and thirdly, a precedent for removal without proof. If we allow that to proceed, my lord, we will not have a republic. My lords and my lady, you will find that in the motion and the proceedings that were before Parliament and the Senate, no evidentiary standard was met. Number two, no constitutional threshold test was satisfied. No fair application of Articles 27, 50, or 150 of our Constitution. What remains is not a legal finding. It is a political conclusion dressed in a constitutional language. If this process is allowed to stand, my lords, evidence will become optional. Allegation will become sufficient. And three, impeachment will become modern instrument of political elimination. At that point, my lord and my ladies, the Constitution will not restrain power, it will serve it. My lords and my lady, this case is not about mere removal of a public officer, the first respondent. It is about whether the Constitution can be bent to serve a political moment. We have quoted in our submission S.S. Smith when he said, constitutionalism is practiced in a country where the government is genuinely accountable to an entity or organ distinct from it, where there are effective legal guarantees of fundamental civil liberties enforced by an independent judiciary. And that's why we are here before you today. The reliefs sought by the 10 to 41st petitioners are contained in our petition, amended petition, and I need not to go to it in the interest of time. But let me say, let's look at these submissions and the petitioner's case from a constitutional flashpoint. What this case is really about. I want to stand here and say, this is not about an election dispute. This is not an election petition. It's a fight for the soul of the Constitution, the soul of this document. That's why we are before you today, my lords and my lady. The three reliefs that I can summarize in the consolidated petition as re-amended are these: that the first petitioner was impeached under a procedure that violated Article 27, 50, and 152 of the Constitution. These are equality before the law, which my learned colleague has elaborately stated, fair hearing, and specific procedure for removal of a deputy president. But two, that the standing orders number 64 and 65 of the National Assembly Standing Orders, 6th edition, as well as standing orders number 78 and 79 of the Senate, as applied, offend, my lord and my lady, Article 152 of the Constitution, the very provision that prescribes how an impeachment is supposed to be conducted. My lords, the impeachment proceedings against the first petitioner was triggered by a political fallout between him and the sixth respondent, the President of the Republic of Kenya, as opposed to a genuine existence of any of the grounds set out under Article 151B of the Constitution. The proceedings, my lord and my lady, before the National Assembly and the Senate were conducted in violation of the substantive and procedural provisions set out or envisaged under our Constitution and the standing order of the respective chambers of Parliament. The Honorable Court is obliged to quash the impeachment of the first petitioner in order to remedy the gross violation of the Constitution and prevent further subversion of Kenya's constitutional democracy and the attendant scheme to establish an imperial presidency. We need to look at the legal anatomy, the constitutional violations at a glance. Article 27 on equality of freedom from discrimination. The question is, why does this provision matter? It matters because the question will be, was the Honorable Rigathi Gachagua singled out by a procedure unavailable to any other citizen? Did Parliament apply double standards in the manner in which it conducted impeachment proceedings against the first petitioner? Article 50 on fair hearing, my lady and my lords, was the impeachment conducted according the first petitioner a fair, adequate, and transparent hearing. The right to be heard is not a technicality, my lord and my lady. It is the backdrop of due process. Much has been said about how the hearing was conducted, even when he was in hospital and was battling for his life. Article 152 on the removal procedure itself. The Constitution prescribes a specific removal procedure. The petitioners say Parliament should change, my clients are saying that the Parliament should change and short-circuited it. If Parliament can alter how a deputy president is removed, my lord and my lady, no constitutional office is safe. Standing orders on National Assembly and the Senate. These are the internal rules used to run the impeachment are themselves unconstitutional. And my colleague has already stated that. The vehicles of the removal are as tainted as the removal itself. My Lord, the petitioner's submissions are anchored not just on law, but also the political reality of our country. And the court cannot ignore this. These scenarios are foregrounded in the opening pages of our submissions. This is what Edwin Sifuna said, and is quoted. William Ruto has basically taken over parliament after the success that he achieved in putting parliament in his pocket. He has now fixed his eyes on the judiciary. We are going to lose this entire republic. That is Senator Edwin Sifuna, Senator of Nairobi. No, I'm just quoting what he said. It is in our submissions. My Lord, the whole state is in arms. That is what Julius Caesar said, 100 BC to 444 BC. And he said, the whole state is in arms. What is then aim of all these preparations but my destruction? Gibson Kamau Kuria, senior counsel, is also cited in our submission, said, the country which started nationhood in 1963 with a constitution which set out to create a tradition of a limited government has an unlimited government which is unmanageable, unable to manage its affairs today. These are not rhetorics, my lady. They are the framing narrative that the impeachment of Gachagua was not an isolated parliamentary act, but a constitutionally dangerous president in a republic where separation of power is increasingly fictional. We have cited in our submissions what Dr. Kamau Kuria created 4 scenarios. The stake could not be higher. He gave a scenario of France of 1789. I had the opportunity of studying European English, European history from 5 and from 6, and Yugoslavia. And this is what Kamau Kuria said, whose words are abducted in our submissions, identified 4 catastrophic features Kenya now contemplate. The first scenario, Kenya becomes France of 1789, or Russia of 1917, a revolution born of constitutional collapse. Scenario number 2, Kenya follows the Somalia, Liberia, Sudan, or Uganda way, a state of fragmentation and perpetual instability. 3, Kenya travels the path of Ghana and Nigeria, circles of democratic failure in former British colonies. And number 4, Kenya fractures like Yugoslavia, ethnic enclaves replacing a unified republic.
Counsel,
The petitioners...
Can I take you on your word?
Yes.
In the next 5 minutes, you can try to wind up.
Kindly, my lady, I'm just about to finish. I'm running. Now, my lady, the core oral proposition, the argument for your determination is this: 5 points. The petitioner will submit as follows. 1, the proposition number 1. The first petitioner is not guilty of ground 6 of the articles of impeachment. The first petitioner was primarily impeached on the basis that he committed crimes under sections 13, 10A, and 62 of National Cohesion Integration Act. The issue of shareholding. I know my colleague here is my friend here. Now it's abandoned the issue of shareholding. It's talking about power. That is my senior colleague. Our core position has been amply pointed out by my colleagues before me, is that the said charge, even when taken at its highest, is not an impeachable offense to justify the removal of the first petitioner from office. There is an element of hypocrisy in the way the issues of shareholding and tribalism was handled by both houses of parliament. Our constitution, my lady and my lords, envisages and encourages ethnic, cultural, religious diversity. Even the concept of devolution is founded on recognition of culture and ethnic identity. Therefore, in the face of Kenya's diversity, the Constitution requires that various state officers led by the president should take into account ethnic and regional diversity in making public appointment and allocation of resources. It's not a new concept. It's in the Constitution. The key point here I'm making is this. Then, is that both ethnicity and tribalism, isn't it that both ethnicity and tribalism realities of a national existence and political dealings? And so this subject must be handled with sensitivity and wisdom as opposed to trivializing or sensationalizing it. Further to the foregoing, it is worth noting that it is the sixth respondent, rather than the first respondent, who can legally and politically be held responsible for skewed public appointments and resource allocation that remain to date a major factor of Kenyan politics. This court should take judicial notice of the manner in which the sixth respondent has systematically appointed state officers to public office, primarily from his ethnic tribe. Yet even it's not subject to impeachment proceedings as the first respondent, by way even when the first respondent never made any such appointments. Proposition 2, Parliament cannot rewrite its own rules to unseat a deputy president. I'm about to finish, my lady. Article 152 of the Constitution is not directory. It is mandatory. The procedure for removing a deputy president is constitutionally prescribed. Any standing order that deviates, breaches, or short-circuits the procedure is pro tanto void. Parliament cannot, by a majority vote on its own internal rules, amend this Constitution. Article 50 guarantees every person the right to fair hearing. The question is not whether Gachagua was given some hearing, but whether the hearing was fair, adequate, and constitutionally compliant, or what my senior colleague Ogola said, malicious compliance. Ongoya. The petitioners on the proposition number 4, equality before the law, means equality of procedure. My Lord, equality before the law also means equality of procedure. Article 27 is violated where a procedure is deployed selectively in a manner that treats one constitutional office bearer different from the standard the Constitution prescribes. The petitioners will demonstrate, and the one that we represent, that the procedure applied in the case of Gachagua would have been impermissible by any other proceedings. 5, impeachment was a symptom, not the disease. The deeper constitutional malady, as the petitioners will argue, is the capture of parliament as a deliberative institution. When senators vote for less money to go to their own counties on presidential instruction, the constitutional architecture of devolution and legislative independence collapse. It is our submission, therefore, that the 13th Parliament has been captured by the executive to an extent that it is no longer possible to consider it as an independent arm of government, or as the Nairobi senator eloquently observed in the quotation that I've just said. So it is our submission that the sixth respondent was ultimately responsible for the political conspiracy and mobilization that enabled the impeachment of the first petitioner from the flimsiest reasons and procedural scandals. In doing so, the sixth respondent abused presidential power in causing the impeachment of the first president of the first petitioner after their fallout. Finally, and on an independent judiciary is now this. This is our last line of defense, this court that we are today. Senator Sifuna won. Okay, I'll skip that.
To be quoting Senator Sifuna every time. When he's not an authority, he does not make any statement. I don't know what obsession.
Relax today, you know, it's about
then Professor Ojenda says something worth quoting, he should be guaranteed I will quote him.
My lady, as I finish, because I'm just a minute, I'm finished. My lady, the 10th and 41st petitioner submit and will argue, never argue orally, that the issue of declaration sought in the re-amended petition confirming the unconstitutionality of both the impeachment procedure and the standing orders that enable it. Number two, affirm unequivocally that Article 152 of the Constitution is not amendable by parliamentary resolution, standing orders, or executive instructions. Number three, send an unmistakable signal that the separation of powers and the independence of the constitutional office are not negotiable. And finally, vindicate the constitutional rights as outlined under Article 27 and Article 50 on equality before the law and fair hearing, in the circumstances where those rights must be visibly and consequentially at stake. So I submit. I've shortened my submission.
Thank you.
My Lord, Ms. Koira will only have less than 10 minutes to say something.
We want to know how many...
On our side is allowed.
Yes.
Yes.
Because we want to structure our proceedings such that when we break for lunch, we come to start the respondent's case. So how many submissions do we have from petitioners?
I think now we have argued like 3. There are 4 more to go.
Hmm?
Are they 3? 3 more?
Yes.
Yes. But the rest were short as we are done. He's taking less than 10 minutes.
So how many do we have? You are how many? Please stand up if you intend to submit.
Yeah, my lord, I'm yet to submit.
How much time will you need?
Like we all agreed before this court, 1 hour. We have very substantive submissions to make, my lord, representing a petitioner.
And you? 15?
We are interested parties in support of the petition.
You take how much time? 20 minutes?
I'll take less than 10 minutes.
So divide that by 2 and then proceed.
My lord, good afternoon. The matter. My name is Koira Kimani. My lord, a lot has been spoken by the 2 speakers who are before me. I wish to not regurgitate that information that has been given, but just to say 2 things, my lord. The impeachment process that the first petitioner was subjected to is one that has raised a theme of fair hearing. In particular, my lords, I will be referring to paragraph 47 of our submissions. There we reference the grounds 1 of the articles of impeachment. In that ground, Your Honor, it was submitted, and I quote, that His Excellency Rigathi Gachagua's divisive and insightful public utterances over the last 2 years were incompatible with the high calling, stirred ethnic hatred, and falsely alluded to a non-existing government policy to discriminate. My lords, it is the submissions of the petitioners that there had to be a particularized statements following that charge in which the Deputy President could respond to. There was none. These statements were very speculative, and in any case, no proof at all was ever produced before the August House to reference that there was indeed a government policy that appeared to suggest certain communities were being segregated or discriminated from the enjoyment of the services that were rendered. Number 2, my lords, we wish to submit that as a deputy president, the first petitioner is the principal, his role is just to deputize the president. it therefore follows, my Lord, that if there was any action to which the first petitioner could be subjected to impeachment, then that process had to be within the framework of Article 147, what was delegated to the Deputy President in his exercise of the function, and what is it that he did that did not align with the mandate. Any other issue that the Deputy President was impeached that didn't follow within the framework of Article 147, then that was a private issue, and there is a cause that any aggrieved party ought to have followed other than the impeachment process. My Lord, lastly, allow me to make reference to our prayers in our amended petition, and specifically prayer number 6 and prayer number 7. For good record, we state that a declaration be issued to declare that the 14 days period prescribed under Article 149 for the President to nominate a person to occupy the office is to ensure compliance with Article 10, 38, 99, and 137, and thereafter, a declaration be issued to declare that the 60 days period prescribed under Article 149 of the Constitution to the National Assembly to vote on the President's nomination. My point is this, my lords, is that there's a time frame in which these things have to be done. It wasn't, it's a matter that is cast in stone, that there is a difference between the 14 days of nomination and number 2, the consideration of 60 days. A lot has also been submitted before this bench in relation to public participation. My Lord, when that order of Kirinyaga was made that public participation be done, my Lord, we were not even granted, Kenyans were not even granted 10 days out of the 60 days, my Lord, to put in their concerns about the choice of the Deputy President. My Lord, it also follows that under our political democracy, the presidency, it's a matter of a conjoined twins. You come in as a president with your deputy president. For various reasons, my Lord, I wasn't for the president, but I elected him by virtue of the first petitioners. That being the case, if then they were not okay with the vice president, any Kenyan who actually made a similar finding while voting ought to have been granted sufficient time to scrutinize the candidature of the incoming deputy president to ensure to vote. And why am I saying this, my lords? Post-election, post-clearance by the IEBC, candidates, all political candidates are granted almost an average of around 90 days to do a campaign, to go to the people, to convince the people that I'm the right person to lead you in this country. But when it comes to nomination, my Lord, of the Deputy President, to which I participated in voting, I'm only granted a day, 2 days, a trial of 1 day. There's a reason as to why, Your Honor, the Constitution puts a 14-day timeline on presidential petitions, whereas there has been debate to extend that timeline, but it's 14 days. That is to ensure that, of course, there's no urgency, because if we were to follow then the reason, if this bench was to say that that impeachment process was lawful, it means this country is yet to see probably a declaration of invalidity or validity of an election, presidential election outcome within 1 day, and to say, but the petitioners and the respondents were all granted time, and a decision was made by the Supreme Court either within 1 day or within 2 days. My Lord, that was not the intention of the citizens of this country, and we urge you to accord us the prayers that we've sought in our amended petition. Thank you, my lords, and I'll be to sit.
Thank you.
My lords, that is all for the 10th to 41st petitioners. We request that the further re-amended petition be allowed.
Thank you very much. Mr. Ndegwa will give you 45 minutes. Don't go beyond 45. Yes.
I will let you know when you have 10 to go.
Again, I will try my best. Thank you, my lords, my ladies. Permit me to begin by indicating that as we appear before you this afternoon, the heavy weight of our Constitution, or rather I feel the overwhelming weight of our Constitution resting over my shoulder. It's my sincere hope that this weight, during the time of the interrogation of the submissions, will equally continue to rest on this court's shoulders. Why do I say so, Your Lordship? I say so because it is important for us to begin by understanding the preamble to the Constitution. When we were giving ourselves this Constitution, these are some of the sacred promises we gave unto ourselves. One of it was that we recognized the aspiration of the Kenyans people for a government.
You have 44 to 49 petitioners.
Yes, 44th to 49.
Yes.
I indicated, my Lord, that when we gave ourselves this Constitution, the people of Kenya recognized their aspirations for a government that is based on essential values, human rights, equality, freedom, democracy, social justice, and the rule of law. That is what we promised ourselves. Number two, we promised ourselves to exercising our sovereign power and unalienable rights to determine the form of governance of our country, and we give it to ourselves and the future generation. That is why I said, Your Lordship, that this case before you is not about His Excellency Rigathi Gachagua. It's about the posterity of our nation, the success of our democracy, and the fidelity to our Constitution. I therefore wish to submit that I participated in these proceedings during the Senate, and I submit that there was no impeachment that took place at the Senate. All what happened at the Senate, my ladies, my lords, was a mockery of an impeachment, a travesty of justice, the transgression of our Constitution. Your Lordship, it has been submitted earlier on by my learned friends that the question that begs the mind of this court is, was this the most appropriate avenue of addressing the alleged transgressions? Or is impeachment contemplated by our Constitution as a matter of last resort? I submit, Your Lordship, that impeachment, though a constitutional tool of enhancing accountability and good governance, must be deployed as a matter of the last resort, and especially to a person holding the office of a deputy president. Why so, my lords? Because we must be able to distinguish between the impeachment that is designated for a president and an impeachment that is designated for a deputy president. And the point of departure, Your Lordship, is Article 143, that the deputy president enjoys no immunity from criminal and civil proceedings. That is to say, if there is evidence that the deputy president has committed illegal transgressions, the avenue that is applicable for addressing that particular issue is to interrogate the law applicable in addressing that particular issue. So that, Your Lordship, that you subject these individuals or this individual to a process that will be less injurious to the sovereignty of the people. Remember, the office of the Deputy President, Your Lordship, though derivative of the office of the President, is distinguishable. And that's your lordship. Article 150 of the Constitution, as read together with Order number 76 of the Standing Orders of Senate, requires Parliament, that is the Senate, to enhance the necessary modification when initiating this process. Your Lordship, the Constitution provides, under Article 150, Clause 2, that the provisions of Article 144 and Article 145 relating to the removal of the President shall apply, comma, with necessary modifications to the removal of the Deputy President. This necessary modification, Your Lordship, is supposed to appreciate the fact that the Deputy President enjoys no legal immunity, and hence inviting the person who accuses him or her to deploy other legal mechanisms that are available to address the grievance. Your Lordship, we submit that there was serious transgression of this provision, that the Senate did not deploy the modification of its standing orders and this procedure. The failure to modify, Your Lordship, meant that the Deputy President was therefore impeached under Article 144 and Article 145. He was impeached as though he is the President. And that is a transgression and the violation of the Constitution. The evidence on Mr. Nyengenye's affidavit in regard to the Hansons will bear as evidence that the Speaker did not deploy the modification mechanisms. The failure to modify this mechanism, Your Lordship, meant that the Deputy President was denied the available legal tools under Article 50 of a fair hearing. Your Lordship, this modification, Your Lordship, means something. It is meant to address something. It is not just there to decorate our Constitution. It was imperative upon the Speaker to inform the Senate of the necessity to modify the procedures for impeaching the Deputy President. Number two, Your Lordship, permit me to draw your attention to Standing Order number 78. This Standing Order number 78 has been addressed vigorously by my predecessors, but let us look at it from a different perspective. The Senate is saying that the Speaker shall, within 14 days, convene a meeting of the Senate to hear the charges against the President, read Deputy President, comma, and the Senate, comma, by a resolution, comma, may appoint a special committee comprising of 11. My humble submissions, my Lord, is that we have two avenues or two forums where this impeachment can take place. The first impeachment is where the Senate sits as a plenary and as it did. The second avenue is where it contemplates by its resolution to create a special committee. Be that as it may, and even if we were to evaluate the two scenarios, the question is, the scenario and the mechanism that was deployed in the impeachment of the Deputy President, did it end up in upholding the Deputy President's rights? Your Lordship, it's my humble submissions that the Senate could equally impeach the Deputy President through a plenary. But when initiating this plenary mechanism, the Constitution, the standing orders requires that there be a modification so that this modification will put into place the rules of procedure to ensure that fair hearing is achieved. And this fair hearing, Your Lordship, you'll find it at Order number 80, the right to be heard of the Senate. Whenever the Constitution or any written law requires the Senate to consider a petition or a proposal for the removal of a person, the person shall shall be entitled to appear before the relevant committee of the Senate to consider the matter, and the Senate and shall be entitled to a legal representation. Your Lordship, my argument or my submission is that even when the Senate decided to deploy the first forum of the Senate being the impeachment crowd as a plenary, they did not provide the procedures for the impeachment that would have ensured that a right to a fair hearing is accorded to the Deputy President. What that means, Your Lordship, is that the Deputy President was denied an opportunity under Article 27 of equal protection, equal enjoyment, and equal protection before the law. That amounted to a transgression. It amounted to an infringement. It amounted to a violation. But Your Lordship, again, you might want to ask yourself whether the Speaker had the responsibility and the duty to guide the Senate when the Senate realized that they are going for the plenary and the plenary has not provided for the mechanism. Order 1 says, Your Lordship, of the Senate rules, in all cases where matters are not expressly provided for by the standing orders or by other orders of the Senate, any procedural question shall be decided by the Speaker. The Speaker did not deploy this mechanism. The Speaker did not initiate this provision. That is to say, Your Lordship, that the Senate fell into serious legal error, fundamentally breached the Constitution and its own standing orders, Your Lordship. Your Lordship, therefore, you must want to ask yourself, in a situation such as this one, was there an impeachment? Your Lordship, it's important for us to remember what Wambora 21, Civil Appeal number 21 says. Civil Appeal number 21, which my learned senior counsel Paul Moita indicated that I was involved in its development, contemplates a two-tier approach to the impeachment. The first tier is where the judges of the Court of Appeal says that this is a political, quasi-judicial process. A quasi-judicial process, Your Lordship, is a tribunal. The Senate sat as a tribunal. The Parliament, National Assembly, equally sat as a tribunal. When it is sitting as a tribunal, it cannot be exempted, Your Lordship, from the dictates of a fair hearing, equal protection of the law, and all procedures that invites it to uphold the Constitution. It's my humble submission, Your Lordship, that in the absence of the provisions that I have quoted, Your Lordship, this could not have been said to have amounted to an impeachment. Your Lordship, that decision, Your Lordship, the Wambora decision, the judges of the Court of Appeal relied in the case of Madbury versus Madson. And this is what the judges said. It is at paragraph 32, Your Lordship. It is our considered view that insofar as the process of removal of a governor, read Deputy President, from office is concerned, the province of the court is solely to decide on the rights of an individual and not to inquire how the county assembly or the Senate performed its obligations. So even when there is a violation of a right to lordship, our submission is, if the court finds that Article 50 of the Constitution was violated, and it was a right that was available to the Deputy President, or Article 27 was violated, and that right was available, then the court must pronounce itself by making sure that it admits our petition. Your Lordship, I invite you to look at paragraph 37 of the same decision, paragraph 39 of the decision, 40, 41, and 42. And most importantly, on the standard of proof. Your Lordship, it's my humble submission that when the Senate or the National Assembly sit as a quasi-judicial organ, whatever submissions or contributions members of the Senate or the National Assembly contribute to must speak to the fact in issue, because it is sitting as a tribunal. That is to say, therefore, Your Lordship, the message coming from the floor of the assemblies must speak to the motion. It must speak to substantiating the motion. But Your Lordship, when you look at the various members, how they contributed to the motion that was before the assembly, and Your Lordship, I would wish to begin by looking at what transpired in the National Assembly. The same evidence finds itself at the Nyengenye's affidavit. Look at what Honorable Ibrahim Sane said. This is what he said, I'll quote. I want to bring out 3 assertions which are highly distorted, emanating from His Excellency the Deputy President Gachagua. The second thing is that one who calls himself a co-president. So this member of parliament who voted for the motion was aggrieved by mere perceptions. He says, the second thing is that he always talks of having acquired a paramilitary training. He is supposed to be a symbol of harmony. So how did the issues of paramilitary, were they part and parcel of what was being considered? Even if, Your Lordship, you are to look at the Evidence Act, Section 5, as well as Section 35, on the relevance of evidence and its admissibility, Your Lordship, does this member of parliament speak to the motion? He is aggrieved that His Excellency considers and says that he has acquired paramilitary training. Look at what Ali Rosa says, member for SACU, UDA. The national unity is one of the reasons the Deputy President must be impeached. He came into public stage to talk about an issue that eventually would undermine, discriminate the minorities. What issue was he speaking about? He was addressing the issues of 1 man, 1 vote, 1 shilling. This member is aggrieved by an issue that was out in the public domain. The country was seriously engaged even during the time of the BBI with the argument of 1 man, 1 shilling, 1 vote. For that reason, he votes to impeach the Deputy President. The relevance, Your Lordship, the relevance of evidence. The nexus between what transpired in the Senate and the National Assembly to the motion in issue. The nexus. Your Lordship, let me just look at what Honorable Elijah Kororia says, member for Gatondo North. The rest you read, my lords. I want to remind this House that during the swearing-in ceremony at Moi International Sports Center, Kasarani, he humiliated Honorable Uhuru Muigai Kenyatta so badly before the nation and visiting dignitaries in the Republic of Kenya. This member of parliament for Gatondo did not make any further submissions on the motion. He was aggrieved by issues that were irrelevant, irrational, and unreasonable. How was there any particulars in the motion that spoke about the conduct of the Deputy President during the swearing-in? Again, look at Honorable Kagombe, member for Gatondo South. Again, he speaks irrelevant issues, Your Lordship. What am I saying? Again, you also look at what the member, the women rep for Nyandarua said. She was aggrieved, Honorable Faith Gitau, that the Deputy President has no respect for women. The reading of the motion, Your Lordship, I did not see any charge that invited the National Assembly or the Senate to evaluate such kind of conduct. There was no particulars and there was no charge. That is to say, Your Lordship, again, allow me to take you to the Senate and look at what Senator Tabitha Keroche says. This is what he says. If the boss decides that he does not want an employee, what can you do about it? It tells Your Lordship, this was a predisposition and a prejudged outcome. And you see, Your Lordship, when seated at the Senate, each senator sits as undistinguished and distinct jury. So this jury, Your Lordship, when he makes this kind of perceptions, political perceptions, they have the capacity and the possibility of persuading other members of the Senate. Because each vote of the member of the Senate is cast as an individual vote. So, Your Lordship, then you want to ask yourself, look at what, again, what my learned friend, senior counsel or gender is aggrieved by. Again, we shall quote him. We shall quote him. We'll have no... So Sifuna said that, Sifuna says that he has looked at the motion. He has found that the motion does not fit well in law. But what does he do? At the fullness of time, he votes for the motion. He impeaches. You need to distinguish the conduct between Tabitha Keroche and Honorable Sifuna. Keroche is a layman or a woman. Sifuna is an advocate of this court. But even in the absence of evidence, in the absence of law supporting the process, Sifuna impeaches. Even after making a valid observation that this motion is not worth the paper it's written on. But he impeaches. It tells Your Lordship that what was happening there was not an impeachment. The Senate and the National Assembly was not in pursuit of good governance. It was not in pursuit of transparency. It was not in pursuit of accountability. It was not in pursuit of the rule of law. It was in pursuit of political elimination. That is what guided the Senate. And Your Lordship, then you might want to ask yourself, whether such a motion, Your Lordship, the nexus between the contribution of the members of the Senate and the motion. Wambora 21 says that there must be a nexus. And not just the nexus between about the contribution, but even the particulars that are alleged to have been transgressed and the person facing the impeachment. Your Lordship, again I remind you that in 1966, during the Uganda crisis, when Milton Obote, the then Prime Minister, decided to dislodge Edward Kabaka Mutesa II, there was a minister called Grace Ibingira. He was a minister of constitutional affairs. And during that time, there used to exist the deportation of undesirable characters ordinance. That is, you find it in our law reports, East Africa law report. So the ordinance was being used by Kabaka and the protectorate then to deport undesired characters to the harsh Karamoja region. Then came in Obote, and Obote proposed, let us repeal this law. Ibingira, being the Minister for Constitutional Affairs, objected to the repealing of that law because he thought that that law would be used to serve the enemies that would be perceived. Do you know what, Your Lordship? Ibingira was the first person who was deported under that law to Karamoja region. That draws a lesson, Your Lordship, for us all. That this impeachment is not about His Excellency Rigathi Gachagua. Again, I confirm, it's about the posterity of our nation. Your Lordship, when it was argued that His Excellency has been taken ill, my submission, Your Lordship, is that Article 19, Article 21, Article 20, Article 24, Article 25, Article 27, and Article 28 kicked in. We are no longer now looking at the expediency of the impeachment, but looking at the right of that particular individual, the right to life, right to equal protection before the law, right to the dignity. That is what we are looking at. The Senate ignored all those. But what does Wambora tell you? Wambora case tells you, look and see whether there was a violation of the rights. Your Lordship, our submission is that there was serious transgression of those rights. Your Lordship, permit me to draw your attention to section, as I go to my next point, Article 138 of the Constitution. Clause 2. It speaks about the procedure at the presidential elections. I will draw parallel later. If two or more candidates for the president are nominated, an election shall be held in each constituency. My interest is the word each constituency. When looking at this, Your Lordship, and having submitted earlier that the office of the Deputy President are derivative of the office of the President, When the Nation Assembly was called upon to initiate public participation, they were supposed to initiate this public participation in the same manner and the same mode this particular person they're removing from office came into office. You reckon, Your Lordship, that in the case of Maina Kiai, it was decided that the election is at the polling center. That election at the polling center, Your Lordship, is the most minute space where the people can exercise their sovereignty. So if we are putting in a president and the deputy president at the polling station, how do you remove him at the county headquarters? How do you make relevance of the county headquarters being the forum for public participation? How did my mother in Karusho participate in the removal of the deputy president? Yet that removal affects her sovereign will. So, Your Lordship, I will draw you to an affidavit by my friend David Madenge. David Madenge is not just any other individual. David Munyi Madenge is a member of the County Assembly of Kirinyaga. He says at paragraph 9, paragraph 11, that he participated in that process. He has even annexed photos in that particular affidavit where individuals were blocked from accessing those so-called public participation forums. This is an elected member. His affidavit must be considered in the weight it deserves, having been a member who is already enjoying the sovereignty of the people. And again, Your Lordship, when you're looking at this affidavit, again look at the annexure marked as PP, as DMM1. This is the National Assembly announcement or notification of the extension of the public participation. They quote and rely on the decision of your brother, Justice Mwongo. Justice Mwongo, and that is the reason why my learned friend, the Member of Parliament for Kirinyaga, Honorable Njeri, referred to the notice of motion that brought forth these particular orders, was specific as to the forums where the public participation was to take place. The judge was therefore reading Article 138, Clause 2, that we must go as close as possible. We must decentralize as much as we can to ensure that there is meaningful, there is quantitative and qualitative public participation. But when you put it in a notice like this, my mother at Karusho, she hardly reads newspapers. She hardly reads newspapers. And Karusho, Your Lordship, is about 130 kilometers from where we are seated. We also have individuals from where we are seated in Banisa who are 700 kilometers from where we are. A newspaper is published. Tell me how Galo, how Muhammad, how Hassan had the ability to participate in this process. Just become pragmatic, my lords. View it in that lens. Your Lordship, as I sum up, permit me again to draw your attention to Article 50. Article 50, Clause 2, Paragraph H. Your Lordship, the Deputy President was unable to attend to his defense. Most importantly, Your Lordship, for this court to note, is that the Deputy President was the only witness for that case. He was not to call any other witness. And he has been denied an opportunity to defend himself. You will hear my learned friend, Senior Counsel Tom Ojenda, telling you that Article 50, Clause 2, paragraph H, permits such kind of a conduct. It says, Your Lordship, every accused person has a right to a fair trial, which includes the right, H, to be present when being tried, unless the conduct of the accused persons makes it impossible for the trial to proceed. I am very sure they would have relied on that, Your Lordship. Let me preempt them. Your Lordship, two things here. In Wambora's case, Wambora indicates, that is Wambora, the locus classicus, that the process of the impeachment is neither criminal nor civil. Therefore, this provision cannot be taken as an exemption to create the necessity for the Deputy President to be available during the process of the impeachment, because it's distinguished that this specifically applies to an accused person. And Wambora has said that an impeachment is neither criminal nor civil. So there was no possibility, Your Lordship, that his presence could have been done away with. It was mandatory, Your Lordship, for the Deputy President to be present during the trial. As I sum up, Your Lordship, you might then ask yourself, in the circumstances, Your Lordship, where an individual has not been heard, where a person has pleaded his unavailability as a result of illness, what was available for the Senate to do? I sat through, I was present, Senior Counsel Paul Moite making an application for adjournment up to Tuesday. They rushed as if London was burning to deny that right. What was the reason, Your Lordship? They said that this was a time-bound process. That's a fallacy. That is a legal fallacy. This was not a time-bound process. And I look at it in two ways. If we were to say, Your Lordship, that the impeachment was to take place at the committee stage, there were 10 days provided for. If you were to say that the impeachment, therefore, was to take place as it did in the plenary, there were no rules requiring or giving the time period within which that process must be complete. May I repeat? When they opted for the plenary, and when they failed to modify this process so as to bring into conformity with the circumstances of the case and to create the necessary legal procedures for the impeachment, they went for it in a blanket manner, because the plenary itself did not prescribe the time period within which this impeachment must be completed. Your Lordship, to the extent that this Senate failed to grant the Deputy President an opportunity to defend himself and hid behind the timelines, which are not constitutionally provided for because they went for the plenary, then, Your Lordship, there was a transgression of Article 25, which provides for the non-derogable rights, and a transgression and a violation of Article 50. We cannot look at it in any other way. There were no rules. The Speaker did not guide the members of the Senate as to how the plenary was to proceed if it were to sit as a quasi-judicial process. Lordship, as I invite my learned friend, Mr. Nyamu, permit me, Your Lordship, to urge you to admit these petitions. I equally associate myself with the submissions made in petition by the first petitioner and all the petitioners who have submitted before. But again, look at the affidavit of Honorable Jerry Maina. Again, Honorable Jerry Maina is not any other person. She's an MP, a member of parliament, who sat all through in that parliament, who sat and contributed to that motion. When she tells you that in her constituency there was no public participation, who am I to deny? Who am I not to believe her? She's elected. She has a distinct, identifiable constituency that her affidavit speaks about. Your Lordship, permit me to invite my learned friend, Mr. Nyamu, and urge you, Your Lordship, to find that there was no impeachment at all, and my Lord, to quash the said impeachment. But while quashing it, Your Lordship, again remember that there is nothing unjusticiable before you. The question of justiciability has been dealt with in the case of Wambora 21, and again, the case of unjusticiability, Your Lordship, that constitutional virginity was penetrated when Article 165, Clause 3, Paragraph D was enacted. That this court can penetrate the works of the Senate, the works of the National Assembly, to see to it whether it was done in accordance to the Constitution. It no longer enjoys that constitutional virginity. Mr. Nyamu. Thank you, Lordship.
Thank you.
Thank you, my lords and my lady.
Yes.
In the interest of justice and time, I do not need 10 minutes. I only need 4.5 minutes.
Yes.
My lords, my lady, my learned colleague, Degwa, has submitted exhaustively. So, I will only be enumerating the reliefs sought. My lords and my lady, at the heart of this petition lies the doctrine of popular sovereignty, as codified under Article 1, which vests the sovereignty or the sovereign power in the people of Kenya and permits its exercise either directly or through the democratically elected representatives. My lords and my lady, the office of the Deputy President is not an appointed or technocratic office. It is a direct product of a universal suffrage, deriving its legitimacy from the will of the electorates expressed at the ballot. It therefore follows that any process that seeks to remove a deputy president from office must be approached with heightened constitutional sensitivity and restraint. It implicates not merely the tenure of an individual office holder, but the sovereign will of the people themselves. Therefore, as a result, and culminating from our submissions, we have sought the following reliefs. 1, a declaration that the impeachment proceedings against the Deputy President were conducted in violation of the Constitution of Kenya and were therefore unconstitutional, null and void. Number 2, a declaration that failure to apply the modification framework under Article 152, read together with Article 144 and 145, as required, rendered the entire impeachment process fatally defective. C, a declaration that the proceedings violated the petitioner's right under Article 52A, as well as 26, 28, 48 of the Constitution. D, a declaration that the Senate acted in breach of its own standing orders, including standing orders number 75, 78, and 80, thereby rendering the proceedings procedurally ultra-vires. E, an order of certiorari quashing the impeachment decision and all consequential actions arising therefrom. F, an order of prohibition restraining the implementation, enforcement, or further reliance upon the impugned impeachment decision. And lastly, any other consequential or auxiliary order that this honorable court may deem fit and just to grant. Thank you very much, my lords and my lady.
Thank you.
Your Honor, I had asked for 15 minutes. I'll try to maintain that. I acknowledge that I see I'm the last petitioner. It's based on, I believe the petitioners are really exhausted and have given admirable, so their submissions with admirable force and clarity that I feel like I'll only be doing closing remarks because they have almost said everything.
Please tell us your name.
I'm Milimani for the 58th petition.
th
58th petition.
Yes.
Yeah, 58th.
They are not here.
Yes, Your Honor. Your Honor, we do rely on our petition, which is dated the 18th of October 2024 and amended on the 23rd of October 2024. Our submissions are also dated, our submissions and list of authorities dated the 2nd of January 2026. Your Honor, I'll seek not to traverse grounds that have already been submitted upon by my fellow petitioners. I'll only seek to maybe highlight or underscore cardinal aspects that I think maybe have not been mentioned or have not been given in the flavor that the petitioner herein may have wanted to do. Your Honor, we do submit that, looking even at our submissions, we submit that this impeachment does rest on one singular but profound constitutional question. And simply, this question, which relates to the issues that we've put before this court, is whether the impeachment of the Deputy President, the former Deputy President Rigathi Gachagua, His Excellency Rigathi Gachagua, was conducted in accordance with the Constitution, or whether it represent, or whether that impeachment process only represents what we term as a fundamental misapplication of constitutional power. In our submissions, we submit that the impeachment process in its entirety is a definite misapplication on constitutional power. And when we speak to constitutional power, we do rest our arguments on Chapter 1 of the Constitution of Kenya. Article 1.1 of the Constitution of Kenya does state that sovereign power belongs to the people of Kenya and shall be exercised only in accordance with that Constitution. And when you read that provision, Article 1.1, we are reading it together with Article 1.3, which provides on how this sovereign is to be exercised through delegated power. And this delegated power has been delegated to the three arms of government. And in our submissions is that the parliament violated this power that has been given by the people. And we say that when delegated power, which the parliament wielded so capriciously for political convenience against the very people from whom that power was given, that exercise ceased to be constitutional governance and only descended to be constitutional betrayal. And you see a parliament that indeed betrayed the sovereign power that has been given by the people and conducted an impeachment process that is not only unfair, but also an impeachment process that gravely violates very many provisions of the Constitution. In our petition, we quoted 20 provisions of that constitution. The petitioners that have come before me have listed a lot of those provisions. I wish not to repeat. But only in summarizing my arguments under Article 1.1, I seek to remind this court of the quote by Justice Emeritus Chief Justice Maraga, when he said that the greatness of any nation lies in its fidelity to the Constitution and adherence to the rule of law, and above all, respect to God. And we also submit that the only way to preserve the rule of law is to apply it equally to everyone. And many petitioners who have come before me, they have said that the impeachment process fell well below the standard of the Constitution. Your Honor, this impeachment process, as it is, opens a constitutional backdoor to power. It provides an alternative way in which the direct vote of the people has an alternative, whereby we can easily impeach a leader who has been validly elected by the people through such of a sham of an impeachment process. And we urge this court to shut this door, because this impeachment, the way it was done, it puts the country at a very bad position, and as it has only left a constitutional backdoor to power, which we submit should not be allowed, as it will be an alternative pathway to electoral process, which is the direct power of the people, which is provided under Article 1. On fair hearing, Article 50, I wish not to dwell on this, because the petitioners before me have really exhausted this ground. But I wish maybe to remind, I remember when my senior, Mr. Ongoya, was presenting his submissions before you, he listed 3 trials that he termed as predetermined trials with unfair outcome. I do not know the 2, but I know at least the trial of Jesus Christ. And I say in my humble submission that at least with the trial of Jesus Christ, Jesus was given the opportunity to be heard. In this impeachment process, it really, when you look at it, and you look in a constitutional democracy of the 21st century, such as Kenya, with a constitution that is celebrated across the globe, with a constitution that has fidelity to human rights and due process, you can really make a conclusion that this parliament sank very low. Even when you look even at the conduct of the speakers of both parliament, and I also relate it to the trial of Jesus, I say that at least the Pontius Pilate washed his hands when he saw that people could not move. But when you look at the Senate, instead of calling the House to order, they prevailed even to vote. Like the Speaker of the Senate went ahead to put a vote on whether someone's constitutional rights of a fair hearing should be respected. Your Honor, Article 50 contains rights that are not only inalienable, but also non-derogable. And that was a great violation of the Constitution. Your Honor, I seek to move to Article 145 and 150. And the petitioners who have come before me have made arguments both on the threshold and the process. And they have submitted that this process failed in both, not only in process, but also in threshold that is required by the Constitution. When you look at process, and I submit on Article 145(3), they made very many distinct legal arguments on whether it is a discretion or the Constitution requires that there must be a special committee. Your Honor, I'll only argue on English, plain English, even literal rule in interpretation of that provision. Your Honor, when you use the word may and you add and, you remove it as an option. When you say, for instance, I want to see, may I see John and James? It is either you see John and James or you don't. And I submit that that may that has been put there is only functions whereby the Senate may not proceed to impeachment. there might even be a preliminary objection, notice of objection on the floor of Parliament, maybe something that has emanated from the National Assembly that prevents even the Senate itself from proceeding to impeachment. But we submit that as per Article 145 and 150, there must be a special committee for investigations. On the aspect of threshold, the Constitution is very clear. It uses the word serious, it uses the word gross. Your Honor, these words are not ornamental. They have a purpose. The framers of the Constitution put them there for a particular purpose. And by use of those terms, it means that there are offenses that are impeachable, and there are also other offenses that are not impeachable. And as such, we submit that none of those charges met the threshold. And I'd like to maybe dwell on the common ground, the issue of shareholder. When you look at the mover of that motion, there's nothing he presented apart from the argument that when the Deputy President was talking about shareholder, those words were divisive, those words were inciting the public. No other evidence was brought in Parliament. Your Honor, what this mover wanted is that he put himself out as an authority to tell the Parliament, both houses of Parliament, that the term shareholder is inciting, the term shareholder is divisive, the term shareholder is against the National Cohesion and Integration Act, without even the institutional backing of that body, which enjoys public money, taxpayers' money, for it to act. Even the Senate did not proceed to conduct investigation so that they can establish these words divisive, as the National Cohesion and Integration Commission deemed it as insightful and divisive. We submit that it lacked authoritative and institutional support. So it was just the words of the mover of impeachment. I believe we dwell on the Latin phrase of ipsi dixit, which simply refers to somebody, a speaker, simply telling people that, believe me, I'm the authority. This is what I mean when I say that these words are divisive and insightful. On Article 152.
Counsel, you're in your last 2 minutes?
Yes, I'm finalizing. Yes, a minute.
Minute and a half.
Yes, Your Honor. Yes, my lady. Your Honor, as I finish on Article 152, the petitioners who have come before me have made valid arguments on that provision. I'd seek not to go deep into the legal aspects of it. I only seek to direct this, my lords and my lady, to the Senate Hansard on the 17th of October 2024. I see Mr. Ojenda has been, Professor Ojenda has been attacking petitioners for mentioning Sifuna. Let me make a change and mention Okia Omtata. And Mr. Okia Omtata, these words, even if these words are adequate to prove that this provision was violated. He says that I stand here to look at whether the House has complied with the Constitution, and he mentions Article 152 on removal of the Deputy President from office. And he makes similar submissions to what my senior, Mr. Ndego, has made, that the role of a Deputy President is derivative. So when you move to impeach a Deputy President, you must acknowledge that aspect. And he says that these modifications have been couched as a mandatory. So when you're making impeachment of a Deputy President, you must do the necessary modifications. Your Honor, I will not proceed to, I will rest at this position. My prayers are similar to what other petitioners have prayed for because of time. I'll not proceed to mention and rest my submissions at this position. Thank you very much.
Thank you very much. We have come to... Who are you? Oh? How much time do you want?
But you are given directions, I take.
Okay.
So I will use 5 minutes and allow my colleague to use 5 minutes.
All right.
5 minutes, it's now 2:30, so 2:35.
Just before I start, I just wanted to mention that we have filed our trial bundle dated 15th of April on behalf of Kitusa Sheria, and also our submissions unserved.
Your name again?
My name is Mosongo Maosa. I appear alongside Margaret Awor. May I start? Okay. Your Lordships and your Ladyship, our Constitution contains very many promises. I'll just highlight 5 promises. One of it is the promise of constitutional supremacy, that Kenyans, in exercise of their sovereign power, determined in Article 1 and 2 that sovereign power will only be exercised in accordance with the Constitution. And secondly, that the Constitution will remain supreme and at all times be followed by all organs. They were not fake promises, and Kenyans made these promises because they intended to keep every part of it. What you're arguing is that in this process, the respondents did not honor this promise that the Constitution is supreme and must be followed. Secondly, we want to argue that there was a promise that through all processes of governance, there will be transparency and public involvement. In Article 10 and 118, Kenyans had the good intentions to ensure that the promise that in all processes, the public participation of the people will be inculcated. That promise, they intended to keep it. And we are arguing that the respondents did not safeguard this promise. The third is that there is a promise of fair trial and administrative actions. A promise means everything, and once it is broken, sorry means nothing. The first petitioner had been promised by Kenyans that he will be entitled to a fair trial and a fair administrative action. Your Lordship and your Ladyship, broken promises are the reason why some people are scared to trust again, and that's why if I've asked for 5 minutes and I take more 1 minute, you wouldn't trust me again. So the same way, if Kenyans had indicated that the first petitioner would have the right to ask for an adjournment, to be present and appear, and be able to defend his case, and that right is taken away, it is unfair, and some promises can break your heart too. And in this case, he actually ended up in hospital. That this promise that had been, that he will be entitled to public participation before his removal was not safeguarded, that the processes relating to his removal would be fair, and it was not fair, he ended up sick. And we are saying that in the same manner, we urge this court to safeguard this promise of a fair trial and administrative action. I still have 1.5 minutes. The fourth promise is that our Constitution, in Article 104, 145, 150, 152, 168, gives the promise of fair removal for state officers. It's not only the Deputy President who is required to be removed in a fair process, but also members of Parliament in Article 104, there's the right to recall. Our learned senior Professor Tomogenda, if the people of Kisumu so wish to recall him, they can recall him, but the Constitution requires that that process must be fair. Even the current president, His Excellency William Ruto, if he has to be removed, the process must be fair. And because we are now setting precedent on how they will be removed, we urge this court that the process and the promise that was given to the Deputy President was not safeguarded. There is no greater fraud than a promise not kept. We urge this court that, as Article 165 states that this honorable court has the power to intervene, and now that my 5 minutes are over, we urge your lordships and your leadership that this promise of judicial protection of this process be safeguarded, that in as much as Parliament did not keep their promise, that this process ultimately, the judicial scrutiny will also be kept. Thank you. I allow Margaret to do the remaining 5 minutes. Thank you, Your Lordships.
Thank you for keeping your promise. Fine.
Thank you, my lordships and my lady. Much has been said about public participation, but what I'll hammer home is the public participation that was conducted by the respondents. The National Assembly did not meet the thresholds of Article 10 and Article 118 of the Constitution of Kenya 2010. The Constitution of Kenya, Article 10 and 118 of the Constitution of Kenya provides that the public participation that should be accorded is one that is reasonable and one that is meaningful. The one that was provided by the National Assembly did not meet these thresholds. Why do I say so? If you look at the public participation that was conducted, it was condensed to 47 hubs, which was conducted in a hurry. And let's take Nakuru ASK showground. It encompassed citizens from Molo, Njoro, Naivasha, Gilgil, Kuresoi South, Kuresoi North, Subukia, Rongai, Bahati, Nakuru, Nakuru Town West, and Nakuru Town East. My lords, my lady, this required citizens to travel from far places to one single center that what they were going to do was to vote, a chat box voting, not an engagement. That did not meet the thresholds of Article 10 and Article 118. Your Honor, sorry, my lords, my lady, you have the mandate or the power to intervene when procedure is not followed, when the procedure that is provided for under the Constitution is not followed. This power is provided for under Article 165(3) of the Constitution, and also as it was hammered in the Wambora case, the Court of Appeal, that you may only come into where necessary to confirm that the process has been properly followed as laid down in the Constitution. We are not inviting this court to intervene or to rewrite politics, but to enforce and preserve the Constitution of Kenya and the rule of law. Our prayers are provided for under paragraph 27 of our replying affidavit. These are our prayers. A declaration that the public participation undertaken by the first and the second respondent in the impeachment process of the first petitioner was neither quantitative nor qualitative as required by the Constitution. A declaration that the notice for public participation issued by the first and the second respondents were inadequate, the time frame provided for was insufficient, and the participatory mechanisms utilized were limited. To declare that the impeachment process failed to meet the constitutional threshold of public participation and is therefore constitutionally defective. Declare that the impeachment proceedings conducted on the 16th day of October 2024 by the third and the fourth respondent were procedurally unfair, unconstitutional, and ultra-vires. Declare that the third and the fourth respondents, acting quasi-judicial, violated Article 47 and 50 of the Constitution of Kenya 2010 by denying cross-examination, re-examination, and a reasonable adjournment. A word, of course, to the seventh interested party, who is Kituo cha Sheria. I humbly submit.
What is the date of your affidavit, and who has deposed to it?
15th April 2026 by Professor Wambua Kituku.
Professor?
Wambua Kituku.
Thank you very much.
Thank you.
I believe that is the close of the petitioner's submissions. Is there any person representing a petitioner who has not been reached, or interested party? We'll break for 40 minutes to come back at 3:20 to commence the respondent's case. 3:20.
I am so hungry. Wanaacha mtu hapa.
Welcome back to the program. The hashtag is NewsGang. We want to talk a little bit about former President Uhuru Kenyatta, who made a mere phone call to an event. So he called his brother, and his brother put a microphone on the phone, and this is what was said.
Mimi kwa ukweli siko kwa active politics, lakini nina haki ya kutetea chama changu. Nina haki ya kusimama na chama changu. Nina haki ya kutetea chama changu. Mimi hakuna kiti yeyote mimi natafuta, lakini mimi ni mwanachama wa Jubilee kwa hali, kwa mali, kwa damu.
Okay, I just have to say, in that clip, he sounds quite like his father, the late Mzee Jomo Kenyatta. I mean, it's just, there's something about it. Maybe it's also the echo and everything that, you know, it just sort of reminds you of the founding father of the nation. But yeah, so he said this, and ghafla bin vu laiti angelijua. The reactions were thick and fast, as Jeff Koinange says. Chairman.
Indeed, I think wishing Uhuru Kenyatta away from Kenyan politics is a bad dream. He sits squarely at the center of our politics. He has a party he leads, a party that intends to run at the highest level of our general elections next year, and therefore anybody trying to wish Uhuru Kenyatta away by trying to confine him to some corner is actually having a bad dream. He is present, and going forward we are going to see more and more of him coming out to campaign for his candidate Fred Matiang'i. Like he rightfully says, that he will be there. He has identified him as somebody who can really do the job that seemingly he says his erstwhile brother has not been able to do very well. But then again, why Uhuru Kenyatta? Every election has a boogeyman. For years it was Raila Amolo Odinga, and in the absence of Raila Amolo Odinga, there is one that is needed, and I think Uhuru Kenyatta has been cast, and he will play that role as we go into the next phase of campaigns.
Yeah, and so serious has been the reaction. There's all of these leaders who have told him to, you know, retire in peace, but they intend to make him pay. Samson Cherargei, the senator for Nandi County, actually says they have a way, they believe they're going to tame him.
The law says in Section 4 that when you leave office, you are allowed a window of 6 months. That should have given an opportunity to hand over Jubilee and to stop making active political engagement.
Before I come to Sam to tell us about this, because he actually did put his motion, present his motion in the Senate, this is what the leadership of the Jubilee Party had to say in former President Uhuru Kenyatta's defense.
Retirement benefits for former presidents are not political favors to be granted or withdrawn at will. They are legal entitlements grounded in law, designed to preserve the dignity of the office.
The retired president makes one phone call, and the government screams the whole weekend.
Yeah, okay, away from that though. So there's a lot of debate about this motion, about what the law says, about what the Constitution of Kenya 2010 says. Sam, this is your moment to do a data point, break it down for us, help us understand this.
Now, first of all, is that motion already received in the Senate?
I doubt it.
Or it's
somewhere
campaigning for it to be adopted.
It's an intention.
Yeah. You know,
Nia. Carry on.
Senator Samson Cherargei has been a senator for 9 years. 9 years when he was supposed to be protecting the interests of counties and defending devolution. I wonder if he looks back, how much of a legacy does he think he has made so far? Knowing too well that when you get an opportunity, you have an opportunity to shape the direction of a country. As one of the youngest senators, I don't know what you would say about his contribution to the Senate in defense of devolution. But all the same, he's going talking about a motion to discipline a former president, and it is within his right anyway to really bring a motion of what he thinks that should be done. He also references the law on retirement benefits and how it is supposed to be followed to the letter, ensuring that the former president does not take part in active politics. But I wonder if he has read the Constitution, because Article 151(3) of the Constitution talks about the retirement benefits payable to a former president and a former deputy president, the facilities available to and the privileges enjoyed by them shall not be varied to their disadvantage during their lifetime. And the simple reading of that statement would tell you that once the Republic of Kenya, through government, accorded former President Uhuru Kenyatta that opportunity to be getting the retirement benefits, there's no way you can go back and take it away, even if the law provides for that. It's actually an issue that has been dealt with by the High Court. I think it was in a court case that was decided in May 2019. Well, look at that, 30th day of May 2019. We are now in May 2026, 7 years apart. But already a decision was made by Justices Nyamoya, Okwany, and Mativo, and they said that a declaration B and is hereby issued that Section 4 of the retirement benefits and designated Deputy President and designated state officers is unconstitutional on grounds that it offends Article 27, 38, 40, 47, 50, and 151(3) and 164 of the Constitution. A declaration B and hereby issued that Section 4 of the retirement benefits is unconstitutional on grounds that it offends the doctrine of separation of powers and common law principles. So in short, what we are saying is that already there's a matter that has been decided to find that in any way that you want to limit the benefits of a former state officer in such a case that, as this one, then already that is flouting the Constitution. And indeed, he went ahead to say that not just those offices, but even every other state officer, public officer, employee, because they come into a job, they send a contract that already talks about retirement benefits. For a president, including President William Ruto, when he came into the office, there's already a law that provides for his retirement benefits. You cannot just take them away because there was already that legitimate expectation. So I don't know how far Senator Samson Cherargei intends to go with this, but I've also seen sentiments from different members of parliament, including Otende Omolo, indicating that this is actually just a waste of time and it stands no chance in this conversation.
Yeah, I mean, when we take a look at a motion, can a motion then be used? So say you wanted to change this because it's in the Constitution, how would you go about it?
You'd need to come up with a bill to amend the Constitution.
Yeah.
But Samson Cherargei is right that the law talks about a motion can be presented in Parliament to take away those benefits. But that has already been dealt with by the High Court, saying that that is unconstitutional and should actually not be forming part of our laws.
All right. In response to Otende Omolo, the senator, he said about 14 hours ago on his Twitter account, my motion is still alive, currently under consideration by the Senate Business Committee and the Speaker. If approved, I will invite you, he says to Otende Omolo, I will invite you to follow the debate at the Senate Speaker's gallery because I'm raising questions, serious constitutional matters and respect to rule of law as indicated in sections 4 and 6 of the Presidential Retirement Benefits Act 2013. And then he says, also, the Constitution provides for freedom of expression and opinion, which every Kenyan is entitled to. So,
who says that? That last part? Who has written that?
This is Senator Cherargei.
So when he reads that, what does he think when he is considering that motion about Uhuru Kenyatta for speaking in politics?
Wow.
Isn't that freedom of expression?
Exactly.
Another person who had one of those drum rolls is the man who was once known as Kang'ata wa Mabarua. And just, was it 6 hours, I believe, after hosting the president in his county?
On Sunday.
Yeah, he said this.
Beyond politics, I hold the view that manufacturing, education and health should be the central pillars of our national policies. Yes, I agree there has been efforts towards these sectors, but the focus and the scale are not yet sufficient to deliver the transformation Kenya requires.
So that was him laying the grounds, because here was the bombshell.
I have had a candid discussion with His Excellency the President, one-on-one, where we shared these ideas, but we did not reach what we call full convergence. I have no doubt to say that after careful reflection, I wish to state that come 2027, I will not defend my seat on the current party ticket.
And of course, he also talked about the prevailing circumstances in the country on the political front.
Recent developments in our political environment raise concern. Instances of confrontation and tension, whether involving leaders, places of worship, those in the opposition, create a perception that politics is drifting towards intolerance. This does not strengthen our democracy. Indeed, it reflects patterns we once collectively opposed.
So, just for context, by the way, he had his jamily, with him at that press conference. That's why you hear, children in the background. But here we are, Jamila, a man who's saying the very things that they collectively opposed is what he's seeing now, saying he told the president this, and this is careful reflection. This is very typical of this man, very unassuming, very easy, much in the same way that he wrote those letters that were quite powerful in Mount Kenya or Central Kenya region during the campaign leading up to the 2022 elections. And he's saying this, Jamila.
You need to put one thing clear, that Kangata is not a weak or struggling politician. He has been ranked or has been said to be one of the governors who has actually been delivering service to the people of his county. He's been said to be one of the most focused governors in the country. He has been seen as someone who's delivering for his people, for the people of Murang'a, especially in healthcare, Yvonne. So, and when I listen to him speak, I find that his wording was careful, because he said that he will continue working with the national government for the rest of the term, but saying that he will announce his platform that he'll run on at a later date. But this means he's stepping away from the vehicle at some point, the vehicle that elected him into power. And I think here we need to look at timing, Yvonne. It's coming at a time when Mount Kenya politics is getting very interesting in terms of after the fallout, of course, of President Ruto and Rigathi Gachagua. There have been complaints about marginalization from that region. And there are signs that maybe some leaders from that region, those who haven't done it already, are reading the public mood and are seeing maybe things will be different. And he says that, and you ask yourself, why would a relatively successful governor, who things seem to be going well for him in his county, choose to start distancing himself from the ruling party ticket?
Yeah.
Because
and it's rather early.
It's rather early.
Yeah.
It could be because, one, he's reading the room, and historically, Kangata has read the room pretty early. Remember, it was the letter you're talking about in 2020-21 when he wrote to President Uhuru Kenyatta, warning that the BBI process was not going to be popular in Mount Kenya. That letter leaked and caused a lot of problems. There was a whole political consequence for him. Remember, at that time, he was removed as Senate Majority Chief Whip. Of course, it was denied that he was removed from that position because of the letter. But that's what happened. And politically, later, he was vindicated because BBI did not get the kind of support in Mount Kenya that they had wanted it to. And eventually, of course, the courts stopped the process. But that history is important, because it tells us that when Kangata has spoken, he's been there before, he's written something before, and he's spoken about political discomfort before in the mountain, before others were actually fully ready to admit it. So maybe he knows what he's talking about. So is the question the question is not only about whether he's defecting from UDA, but the other question is whether he's detecting maybe a political shift that maybe other people don't want to talk about now, and he's detecting it early. We do have a chunk of leaders from Mount Kenya who have clearly said they're not supporting President Ruto's bid for a second term, but there's a group that supports him. So what does this mean for President William Ruto and his strategy and his plan to conquer Mount Kenya again, as he did in 2022? What is the mood in the ground? What is the feeling on the ground? So maybe Irun Kari is someone that they need to listen to and say, hey, if he is stepping away, what does this mean for others in UDA and others who are seeking re-election in 2027?
Yeah, might he be the John the Baptist for this one? You know, go ahead and, you know, talk about what might be coming. We shall see. Probably significant or not in Mount Kenya politics as far as support for President William Ruto goes. So he seems to have made his peace with that decision to not contest.
Unajua hatutaki tuingilie mzozo huo sana manake uko pale mahakamani, lakini jambo ambalo nataka niwakumbushe kila mtu ni kwamba sisi tunazunguka tukisema Kenya ni nchi ambayo inatawaliwa na sheria.
Okay.
Na wakati ambapo jambo limetokea kisha mahakama likatoa agizo kwamba uamuzi fulani usimamishwe kwanza ama ubatilishwe, ni jukumu la kila mtu kuheshimu mahakama. Ndio maana unasikia kila mara sisi tunazungumza kama wana linda mwananchi tunasema kuna maadili fulani chini ya katiba. Maadili moja ni ule utawala wa sheria. Utawala wa sheria unahitaji kwamba kila mtu aweze kuheshimu mahakama.
Okay.
Kwa hivyo unapoona watu wanazungumza kwa njia ambayo sio ya heshima kwa mahakama, na wao pia wamekuja mahakamani kueleza mambo yao jinsi ambavyo waliweza kuafikia ule uamuzi. Inawezekanaje kwamba utoe maneno ambayo yanapelekea kuonyesha kuwa huheshimu hiyo mahakama ambayo wewe pia umekuja pale na unahitaji kwamba wakusikize. Hiyo ndio ile clash ambayo yuko nayo kati ya baadhi wengine wetu na wao, kwamba kuna wale ambao sisi tunaamini katika yale maadili ya kikatiba ambaye inahitaji kwamba kila mtu aweze kuheshimu sheria, kila mtu aweze kuheshimu mahakama. Kwa hivyo kama mahakama imesema kwamba Sifuna bado ndio katibu mkuu wa chama cha ODM, wewe kama mwananchi ambaye unaheshimu sheria lazima utambue kwamba Sifuna bado ndio katibu mkuu wa chama cha ODM.
Mheshimiwa, tuseme kama mahakama itakuacha ofisini, lakini huu mgawanyiko katika chama uendelee vile tunavyoona, huoni kama nafasi yako itakuwa gumu kutekeleza ile wanasema untenable?
Kwanza kabisa nafasi hii si ya Sifuna. Hamna mtu ambaye amezaliwa kwamba nafasi fulani iwe yake kwa maisha. Unavyojua kwamba Mheshimiwa Gatonye kumekuwa kuna makatibu wakuu wengine wa chama cha ODM, na nimesema wazi kwamba najua kwamba kutakuwa kuna makatibu wakuu wengine. Chama cha ODM kina zaidi ya uungwaji mkono wa wafuasi zaidi ya milioni 5. Siwezi kusimama niseme kwamba kati hao milioni 5 Sifuna pekee ndiye anaweza kufanya kazi ya ukatibu. Lakini mgogoro huu ambao uko ndani ya chama, nimesema wazi pia kwamba utasuluhishwa na wanachama wa ODM. Na nimewaomba kwamba kwa sasa, kwa sababu nafasi ambazo watu wameshikilia, watu wamechukua misimamo mikali kuhusu swala moja tu, swala ambalo linagawanya chama cha ODM si kubwa. Ni swala tu la ni nani ama ni vipi chama kiingie katika uchaguzi wa mwaka 2027. Kuna wale ambao wanashikilia kwamba wanataka kumuunga mkono Mheshimiwa William Ruto kwa awamu ya pili. Kuna wengine wetu ambao tunashikilia kwamba nchi hii haiwezi kumudu tena uongozi wa William Ruto zaidi ya miaka 5 nyingine. Kwa hivyo huo mgogoro utatatuliwa na wanachama kwa kusema tunataka tuwape mamlaka kikundi kimoja. Waseme wanaenda na hawa jamaa wa 2 term ama waseme wanaenda na hawa jamaa wa 1 term. Kwa sababu haitawezekana vile wewe mwenyewe unasema. Ile ideological difference ambayo iko sasa na ile gulf ambayo iko pale katikati ni kubwa sana, na sisi tutaheshimu uamuzi wa wanachama wa ODM. Iwapo watasema kwamba wanafikiria kwamba chama kiende na njia ile, tutaheshimu kwa sababu hiyo ndio demokrasia. Unanielewa?
Hii migogoro Mheshimiwa, ukiangalia itaacha chama cha ODM wapi tunapofika uchaguzi wa 2027?
Unajua sasa hiyo ndio tofauti iliyopo pale. Kuna mitazamo tofauti. Mtazamo wangu mwenyewe na ni mambo ambayo nimeweka wazi, si kitu cha siri. Kwamba kuna wale wanasema chama cha ODM kimechoka kuwa katika upinzani. Wanasema wanataka kuwa kwenye serikali. Lakini mimi ninavyowasikiza wa Kenya, Kenya hii ni kama wa Kenya tayari wameamua. Njia haswa ya ODM kujikuta kwenye upinzani tena ni kumuunga William Ruto mkono, kwa sababu mimi naamini kwamba anaenda nyumbani. Wakenya wengi wameamua kwamba hawatampa fursa nyingine ya kuongoza taifa hili mwaka wa 2027. Na unajua sijaelewa hili jambo kwamba upinzani ni kitu kibaya umetokea wapi? Mheshimiwa Raila Amolo Odinga amezikwa na heshima zake akiwa kama kiongozi wa upinzani katika mfumo wa demokrasia, ambapo ni contest of ideas. Inawezekana kwamba leo uwe katika upinzani, kesho uweze kuuza sera zako na Wakenya wa kuunge mkono uwe kwenye serikali. Kwa mfano Gatonye, kule katika nchi ya Marekani kuna vyama viwili vikuu, wale wanajiita Democrats na kuna wale wanajiita Republicans. Miaka 4 tu iliyopita Democrats, hata si 4, miwili tu imepita, kwa sababu kufikia mwaka 2024 wale Democrats ndio walikuwa na Rais Biden. Haya, wamejikuta sasa ni Trump amechukua. Huyu Trump huyu chama cha Republicans wakati anamaliza muda wake hakuna kujua kwamba kama watajikuta kwenye upinzani na Democrats warudi kwenye uongozi. Kwa hivyo haya masuala ya kusema kwamba kwa upinzani ni kitu kibaya, hapana. Hii inatakiwa iwe ni debate kuhusu sera ambazo Wakenya wangependelea na wanaweza kukupea mamlaka fulani. Kama baba amezikwa na heshima hizo zote, wakati huu wote amekuwa kiongozi wa upinzani, very proudly so, alikuwa akijiita yeye mwenyewe father of democracy. Unanielewa? Kwa hivyo wale ambao wanasema upinzani ni kitu kibaya, mimi naona kwamba wamepotoka. Number 2, upinzani haimaanishi kuwa kwenye barabara. Unajua wanatuambia tukitoka kwa serikali tutarudi kwa barabara. No. That is not what we are saying. Haiwezekani kwamba hizo ndo options mbili peke yake. Upinzani inamaanisha na nyinyi pia mtoe sera na mitazamo tofauti kuhusu njia ambapo nchi hii inaweza kuongozwa. Na sisi wanalinda mwananchi tunasema lazima sasa tutangulize mwananchi na maslahi yake. Ukisoma magazeti ya leo atakwambia jinsi ambavyo wengi hapa Nairobi na nchi nzima wanaendelea kupitia wakati mgumu sana, manake hamna fedha katika mifuko ya watu. Na hili ni swala ambalo tunaweza kuketi tuzungumze, tuseme tungependa tufanye njia hii na njia hii ili tuweze kuinua maisha ya wananchi wetu. Kwa hivyo wale ambao wanasema tukitoka broad based tutaenda kwenye barabara, nani aliwaambia? Who told them?
Tunashangaa kidogo mheshimiwa, kwa sababu nyinyi wote hamuongei kwa sauti moja, ilhali tukiangalia nyinyi wote mlikuwa karibu sana na mheshimiwa Raila Odinga. Kwani ni nini kilikuwa kinaendelea, ama watu wengine walikuwa wanaambiwa hivi, wengine wanaambiwa kitu tofauti? Kwa sababu kama nyinyi wote mlikuwa chini ya Raila Odinga, tulikuwa tunatumai mtakuwa mnaongea kwa sauti moja.
Kwanza chama si kwaya. Haiwezekani kwamba watu wataimba wimbo moja kila wakati, na haya maneno yamekuepo kwa muda kwamba kuna unajua mkiwa kikosi cha watu milioni 5, hata kama ni uongozi, kwa mfano lile baraza kuu la chama lina watu kama 40, haiwezekani kwamba watu watakuwa na mtazamo mmoja. Ni kawaida katika demokrasia kwamba watu watakuwa na mtazamo, na haswa swala gumu kama jinsi ambavyo tunaweza kuingia katika uchaguzi wa mwaka 2027. Tofauti ni kwamba unajua mheshimiwa Raila Odinga amekuwa kiongozi wa chama cha ODM kwa muda mrefu na amekuwa kiongozi wa wananchi kwa muda mrefu. Alikuwa na ile kitu ambayo tunaweza kuita kwa kimombo legitimacy. Yani alikuwa amepewa ile nguvu na wananchi ya kuweza kuwatolea uamuzi. Kwa hivyo wakati mwingi yeye ndio alikuwa mwenye kutoa mwelekeo, na kwa sababu ya ile legitimacy alikuwa naye, hata kama ulikuwa na mtazamo tofauti ungekuta kwamba wengi wanasema kama baba amesema, kwa sababu ya ile heshima na pia historia yake, kwamba hata wakati mwingine kama ulikuwa na shauku ama dukuduku kuhusu uamuzi ambao anatoa, tulikuwa na ile imani kwamba baba anajua kitu ambacho ni bora kwetu. Si eti kwamba tulikuwa tunakubaliana na yeye kwa mambo yote. Na hata alipokuwa hai baba alikuwa na ruhusu watu kumkosoa. Nakumbusha watu kila siku kwamba wakati ambapo chama kimeingia katika uchaguzi wa mwaka 2014, kulikuwa na mpinzani wa Raila. Alikuwa anaitwa Mheshimiwa Simba Arati. Baba alimruhusu, yani si hata kumruhusu, hakuwa na shida kwamba alikuwa anaweza kuchallenge ama uamuzi wake ulikuwa unaweza kuwa challenged. So tofauti ni kwamba ule uongozi ambao tunaona kwa sasa ni wale ambao ukimwambia kwamba una mtazamo tofauti anaona ni kana kwamba umemkosea heshima. Unanielewa? Kwa hivyo tukisema tunaweza kufanya jambo hili hivi ama jambo hili vile, anaona ni kama unamkosea heshima. Nataka nikupe mifano ya wakati ambapo tumetofautiana wazi na mheshimiwa Raila Odinga na hakuchukulia swala hilo vibaya. Alituita na akajaribu kutupa maono yake, na sisi tukamwambia baba, sisi tuna mtazamo tofauti. Swala zima la Adani kwa mfano, baba publicly alikuwa anashikilia, anasema kwamba turuhusu mradi huo mzima uweze kuendelea pale katika airport yetu ya JKIA. Sisi katika bunge tulikuwa tunasema na tulimuelezea na alielewa, tukamwambia baba, hamna mtu yoyote ambaye anasema hatuhitaji airport mpya. Hamna mtu ambaye anasema wawekezaji wasije katika nchi yetu kuweza kufanya miradi kama hii chini ya mfumo mzima wa PPP ama private partnership.
Yes.
So ile tulikuwa tunamuelezea tukamwambia, baba, ni wewe ulitufunza kwamba lazima tukifanya jambo lolote tuweke maadili fulani. Maadili ya kwanza ama kile kitu ambacho lazima tushikilie kama ODM ni jambo la uwazi. Kwamba iwapo unataka kufanya mradi katika taifa letu, weka wazi kwamba kwanza tunatafuta mwekezaji ambaye anaweza kututengenezea airport yetu. Dunia nzima ijue. Kisha kila mtu aweze kupata fursa ya kusema mimi nitafanya kwa kiasi fulani cha pesa, design yangu ni hii. Alafu Wakenya waweze kuona jambo gani ambalo yani proposal gani ambaye ni bora zaidi. So baba yeye alituketisha chini na tukamuelezea, tukamwambia, Jacob, hatuna shida na wawekezaji, lakini ulitufunza kwamba lazima kuwe na uwazi. Na baada ya mheshimiwa John Mbadi kuingia pale Treasury na baada ya swala zima la Adani kuwekwa kando, uliona ile wizara ya fedha ikichapisha sasa muongozo ambao utapelekea kuwepo na uwazi haswa katika hii masuala ya PPP. Nimeona juzi hata kulikuwa na proposal nyingine ambayo imekuja kuhusu miundo msingi katika swala zima la stima. Na wakachapisha pale wakasema tumepokea proposal fulani, wanajaribu wanasema watafanya hili na hili na hili, kama mna maoni muweze kutoa. Manake Gatonye, ile shida ambayo iko katika Kenya hii ni hiyo kukosa uwazi na mambo yanafanywa katika chini ya meza ambayo yamefichwa. Sisi kama wana ODM tumefunzwa kwamba miradi si mibaya na hakuna mtu ambaye anakataa maendeleo, lakini tunataka ifanywe kulingana na maadili ya kikatiba.
Lakini ni ukweli Mheshimiwa Sifuna kwamba Raila Odinga aliacha ODM ikiwa kwenye hii serikali ya broad based.
Kwanza unajua unazungumza
kwa nini wewe na wengine mnataka kuitoa pale Raila aliwacha?
Wanazungumza ni kana kwamba Raila Odinga alienda safari. Unajua kama ulikuwa umepanga kitu kwamba ninasafiri mahali, unaweza sema wacha niache mambo yangu yakiwa hapa. Kifo cha Mheshimiwa Raila Odinga si kitu ambacho mtu yote alitarajia. Mnanielewa? Na aliposema ya kwamba tuweze kufanya ushirikiano na serikali ya UDA kwa sasa hadi mwaka 2027, kuna muktadha fulani, kuna mandhari fulani ambayo yalipelekea ililazimisha kwamba tuweze kusaidia serikali hii ili iweze kuwa stable. Wakati ambapo vijana wameingia katika barabara mwaka 2024, serikali nzima imevunjiliwa mbali, nchi iko katika hali ya hatari. Baba akasema sasa jinsi ambavyo vijana kwanza walivyoingia katika makao makuu ya idara ya mahakama, kwa maoni yake baba alikuwa anasema kwamba inamaanisha kwamba unajua nguvu zote ambazo tunazo kama viongozi, whether ni katika idara ya mahakama ama katika bunge ama katika uongozi wa taifa, zinatokana na mamlaka ambayo tumepewa na wananchi. Na wananchi wakati wowote, unaona katiba, sijui kwa nini leo nimesahau kubeba katiba yangu. Katiba inasema kwamba mamlaka ambayo tuko nayo ama wananchi wanayo yanaweza kutekelezwa either directly kupitia viongozi ambao wamechaguliwa ama wafanye wao wenyewe. Unanielewa? Sasa akatuambia kwamba ukiona vijana wameingia mahakamani, wameingia bunge wakafurusha wabunge pale, unaona walikuwa wanaelekea Ikulu, kumaanisha kwamba mamlaka yote ambaye wananchi walikuwa wametupatia imechukuliwa na imerudishwa kwao. Wananchi walikuwa wamechoka kiasi kwamba wanahisi kwamba sisi wabunge hatuwasikizi. Unakumbuka mchakato mzima kuhusu finance bill, kwamba wewe umechaguliwa na watu wa hapa Nairobi kwa mfano, uko katika eneo bunge la Starehe ambapo tuko hapa. Yeye mbunge wa Starehe anaambiwa na wana Starehe wenyewe kwamba katika swala la kutuongezea ushuru piga no. Lakini kwa sababu ukiingia pale bunge kuna false sense ya security, manake kuna viti vizuri kushinda hiki chako cha hapa K24 comfortable kabisa, si ndio? Kuna hii AC inapiga nzuri, kuna polisi pale nje, unaingia pale ndani unafikiria wewe ndio mkubwa wa wananchi, unasahau kwamba wananchi ndio wadosi wako. So ilipofika pale baba akatuambia hawa vijana na wananchi kwa jumla wamechukua mamlaka yao, wamejirudishia mamlaka yao. Akasema tunataka tuwe na mfumo tuweze kusema can we sustain the democracy ya Kenya kwa muda fulani, alafu tuweze kusikizana kwamba kuna mambo fulani yatafanywa. Kwa mfano alikuwa anataka hiyo uamuzi wote wa bunge wa kupitisha hiyo sheria ubatilishwe, wale vijana ambao wameuawa wapewe compensation, polisi ambao walihusika na hayajafanyika. Yani mawazo yake yalikuwa ni hayo. Na ilikuwa tuketi na Mheshimiwa William Ruto tumwambie these are the conditions under which we will stabilize your government. Kabla hatujamaliza kusikizana, wengine wetu wameenda direct kusikizana na Ruto, wao watachukua nafasi katika serikali. Sasa wakati ambapo tangazo hilo, kabla tangazo hilo litolewe, kuna arafa ambayo tulitoa kama chama cha ODM.
Mheshimiwa kidogo, unataka kuniambia wenye walienda serikalini walienda kivyao? Walienda
kivyao. Na kuna arafa ambayo
ilitolewa na baraka.
Ndio nakwambia hakuna mkutano ambao ulikuwa umefanywa jinsi ambavyo baba alikuwa anatarajia kusema kwamba haya ndio mambo ambayo tunaenda kufanya na hawa ndio watu ambao tunaenda kuwatuma waweze kukusaidia kustabilize serikali yako, kisha wakati fulani ukifika tupange uchaguzi maalum ili tuweze kuuliza wananchi kama bado wana imani na wale viongozi ambao wamechaguliwa.
Na bona Mheshimiwa Raila wakati ule alituambia ati serikali ilikuja kwetu tukawapatia experts. Hiyo ni kusema ni kama
nataka kukupatia chronology ya events. Manake Wakenya wanasahau sana. Na pia kwa sababu ya propaganda ambayo inapigwa, watu wanasahau nini kilifanyika kabla ya kipi.
Tueleze
chama cha ODM nikiwa katibu yake, Baba Amolo Odinga alikuwa katika jiji la Dubai. Akatupigia mimi simu, akampigia yule mkurugenzi mkuu wa chama anaitwa Odoro Ngwen. Tulitoa statement siku hiyo na tukasema chama hakijatuma mtu yote katika serikali. Ukiangalia katika mitandao ya kijamii ya chama cha ODM, statement hizo bado ziko pale. Unanielewa? Tukasema yeyote ambaye atajiunga na serikali hii anaenda kwa kutaka yeye na anaenda in their individual capacities. That statement was made. Baadaye hawa ndugu zetu kwa sababu walikuwa wanasikia hiyo pressure na wanaona ni kana kwamba chama kinawatelekeza ama kina abandon, wakaweka pressure sana kwa Mheshimiwa Raila. Ukiangalia period ya kati ambapo tulitoa hiyo arafa wakati wameingia kwa serikali na wakati ambapo baba ameanza kusema ni sawa tulituma kama experts waende kusaidia serikali. Kuna kipindi fulani kilikuwa kimepita pale na mambo mengi yanafanyika nyuma ya tent vile ambavyo vijana wanasema. Kwa hivyo hawa ndugu zetu wanataka kugeuza historia na wanasema historia tayari imeandikwa na ule wino umekauka, hauwezi kubadilisha historia. Hizi mambo yote ambayo nasema, kuna stakabadhi ambazo zitaonyesha statements ambazo zilitolewa na chama ziko pale kwenye mitandao ya kijamii ya chama bado mpaka wa leo. Kwa hivyo hakuna mtu ambaye anaweza sema kwamba Sifuna anasema uongo. Naam.
Wakati huo nakumbuka Mheshimiwa Raila akisema Uhuru Kenyatta alimsawishi kuingia ama kupata kuwa na discussions na William Ruto. Sijui kama unaweza tuelezea kuhusu hili jambo.
Mimi nimemsikia na yeye pia akisema publicly ya kwamba yeye hakuwa radhi kuzungumza na William Ruto. Ya kwamba ni rafiki yake Mheshimiwa Uhuru Kenyatta ambaye alimpigia na akajaribu kumshawishi kwamba kwa ajili ya nchi nzima na taifa zima la Kenya, kwa ajili ya usalama wa wananchi, kwa ajili ya usalama ya mali ya Wakenya, kwa ajili ya usalama wa demokrasia ya nchi, waweze kufanya mapatano ili kuokoa nchi. Na nataka kila siku tukumbuke Gatonya kwamba the reason ilikuwa ni kuokoa nchi. Haikuwa tuende pale tuanze kuimba sifa za William Ruto. Kama baba mwenyewe hakuwa anataka hata kuzungumza na William Ruto, lakini akainuka juu ya yani feelings zake yeye mwenyewe. Akaweka taifa mbele, akasema na alijua atatusiwa, atakejeliwa, atadharauliwa. Kuna watu wengi sana ambao vijana wakasema amewasaliti. Na hicho kitu kilikuwa kinamuuma Mheshimiwa Raila Odinga sana. Hata msemaji wake Dennis Onyango alituambia kwamba baba alikuwa anapanga akirudi kutoka matibabu kule India aingie hapa katika chuo kikuu cha Nairobi kutoa lecture kuelezea Wakenya kuhusu hili swala zima la compromises katika siasa kwa ajili ya nchi. Ilikuwa ni jambo ambalo lilikuwa linamuuma baba sana. Akisikia kwamba watu wanamuita msaliti. Hakusaliti mtu yeyote. In fact baba aliokoa nchi, akasema wacha tuokoe demokrasia, tuweze kufika katika sehemu ambayo tunaweza kumuondoa William Ruto kupitia njia za kidemokrasia. Hiyo ndio ulikuwa msimamo wake.
Kwa hivyo hakukuwa na mpango wowote wa 2027.
Hakukuwa na mpango wowote, na kama kungekuwepo,
wenye wanasema sasa hiyo ni mipango yao wameleta hiyo ni mipango yao. Na utakumbuka kwamba siku 22 kabla baba kuondoka alihutubia taifa na wabunge pale katika hoteli ya Agile pale Mombasa. Na alisema wazi, unajua hata sisi wanasheria wote tunasema unajua yale maneno ya mwisho ambayo mtu amezungumza kabla kifo chake yana uzito fulani. Aliwaambia hawa ndugu zetu, na tulikuwepo sisi wote tulisikia, akasema kwamba chama cha ODM hakijasema unga mkono Mheshimiwa Ruto mwaka 2027, kwamba chama cha ODM ambacho ni chama cha kitaifa kina uwezo wa kutoa mgombezi wa urais katika uchaguzi ule. Unajua Gatonye, tangu chama cha ODM kilipobuniwa mwaka 2005 katika chaguzi zote ambazo zimekuwepo Kenya hii kimekuwa kimtoa
kiongozi ama yule presidential candidate.
Yes.
Kwa hivyo itawezekanaje kwamba baada ya miaka 20 tuingie katika uchaguzi na tuseme kwamba raundi hii hatumtoi kiongozi yeyote? Na kuna wale ambao wanasema ndani ya ODM kwamba baba hakulea mtu yeyote ambaye anaweza kuwa rais. Nikawauliza, kwani baba alikuwa anatufunza kukuwa maseremala? Shule ya Raila Odinga ni shule ya uongozi. Hata hawa ndugu zetu wote ambao wamepata fursa ya kuwa katika nyadhifa kuu za serikali wamepita katika mikono ya Mheshimiwa Raila Odinga. William Ruto ni mwanafunzi wa Raila Odinga. Unanielewa? Kwa hivyo vile ambavyo alisema dada yangu Winnie, kama wewe ulilala darasani, maana yake baba alikuwa anatufunza kila siku. Unajua klasi ya baba ilikuwa inafanyika hata kama haujui klasi inaendelea. So kuna wale ambao walikuwa wanasinzia, kuna wengine walikuwa wamelala, kuna wengine walikuwa nje ya dirisha, mguu mmoja walikuwa washatoa, wanasema wao hawajatosha kuwa viongozi katika taifa hili. Tunawaambia hiyo ni haki yenu, kwamba wewe ukisikia haujaiva toa jamu. Wewe kama hujaiva wewe toa jamu. Lakini usituambie chama kizima hakiwezi kutoa kiongozi.
Chama cha ODM kilifanya mkutano hivi majuzi na bali na kukutoa kama katibu mkuu wa chama. Hiki chama kilijiondoa kwenye muungano wa Azimio. Walitangaza hivyo. Sijui kama hili ni jambo mmekubaliana ama maoni yako ni yapi kuhusu?
Unajua sasa huo uamuzi ulifanywa katika huo mkutano ambao waliniondoa. Kwa hivyo kwamba maoni yangu mimi sasa hawayahitaji tena, ilikuwa baraza la NEC.
Bado wewe ni katibu mkuu mheshimiwa. Sasa ndio nakuuliza kwa maoni yako kwa sasa.
Kwamba unajua ni jambo la kutamausha sana. Manake ukiangalia vyama ambavyo vilikuweko kwenye Azimio vilikuwa zaidi ya vyama 26. Na vyama hivi vilimsaidia sana Mheshimiwa Raila Odinga, na wengine ni wendani wake wa muda mrefu sana. Ukiangalia mtu kama Kalonzo Musyoka amemuunga baba mkono kuanzia mwaka 2013.
Ukweli?
Amemsupport, na ukiangalia hata maeneo ambayo yanamshabikia sana wamekuwa kimpa baba kura almost 100%. Na unajua baba alikuwa anatuambia kwamba safari hizi za coalitions mnatembea na watu ambao yale maadili yenu yanakaribiana ama yanafanana. Kwa hivyo ilinishangaza hata mimi, nilikuwa ningeulizwa mimi kuhusu haya mambo ya mjadala kati ya vyama, singeanza na watu ambao tumejuana juzi. Ningeanza na watu ambao tumetembea nao kwa muda mrefu, niwaulize bado mnaona kwamba mnaweza kutuunga mkono. Na nimesikia kina Kalonzo wakisema, wanasema kama tuliunga baba mkono 2013, 2017 tukamuunga mkono, 2022 hata Kalonzo mwenyewe hakuwa hata kwa ticket ile. Akamruhusu Martha Karua akaingia pale kama naibu wa Raila na bado akatuunga mkono. Akauliza, kama tumefanya hayo yote miaka hii yote ambayo imepita, ni nini kiko ndani ya akili ya ndugu zetu wa ODM ambao wanaona kwamba hatuwezi kufanya vile vile ambavyo tumefanya miaka hii nyingine ambayo imepita? Na mimi kama kiongozi wa chama cha ODM niliona kwamba kulikuwa na nafasi nzuri sana chama hiki cha ODM kuingia katika serikali. Ukiangalia jinsi ambavyo kura zilipigwa mwaka 2022, William Ruto anasemekana kushinda uchaguzi na kura chini ya 1200. Gatonye. Na amepoteza zaidi ya uungwaji mkono wa zaidi ya kura milioni 5 kwa sababu tayari watu wa Mlima Kenya wamemuondokea. Sasa mimi kama kiongozi wa ODM sinaona kuna nafasi nzuri pale. Kwa sababu gap ama ile deficit ya kura milioni 5 sio rahisi kujaza. Na ukumbuke anasemekana kushinda na kura 1200 pekee. Kwa maoni yangu Gatonye, iwapo chama cha ODM kingesalia tu na wale wa ndani ambao tulikuwa nao mwaka 2022, hatukuhitaji kuongeza hata kura moja. Yeye ndiye amepoteza, sisi hatujapoteza lolote. Tungesimama tu na zile kura ambazo baba alipata katika uchaguzi wa mwaka 2022, tungeunda serikali.
So in simple terms, mheshimiwa, you don't support?
Mimi naona kwamba ni uamuzi ambayo hauja make sense kwangu. Watanielezea kwa sababu sijapata fursa ya kuzungumza na wao. Lakini lazima, unajua, mkiwa katika ndoa, hata unapotangaza talaka, lazima umuelezee yule ambaye unampea talaka, awe ni mmeo ama mkeo, ni kipi kimepelekea kwamba talaka hii inatokea. Kama kumekuwepo na ile wanaita udanganyifu katika ndoa, akuambie kama ni vita ama ni nini. Lakini kufikia sasa sijaelewa ni kwa nini sababu ambazo zinapelekea chama kujiondoa katika muungano mzima.
Wakati huo, wakati Azimio walikutana chini ya uongozi wa rais mstaafu Uhuru Kenyatta, pia walitangaza wakasema Junet Mohamed ametolewa kama katibu mkuu wa muungano wa Azimio. Hilo lenyewe naliunga mkono? Mimi kwanza siko katika yani kitengo chochote cha Azimio. Unajua wengi huwa wanatarajia kwamba kwa sababu mimi ni katibu mkuu wa ODM labda nina nafasi katika muungano mzima wa Azimio. Ukiangalia lile baraza kuu la Azimio
wale ambao walikuwa wanatuwakilisha sisi kama ODM ni Mheshimiwa Junet na Mheshimiwa Paranya na kuna wengine wachache. Sasa wao ndio wenye kutuelezea jinsi ambavyo muungano mzima huo umefanya uamuzi, lakini mimi mwenyewe siwezi kutoa maoni kuhusu uamuzi wa council ambaye mimi huwa sikai ndani. Unaona, lakini kama wamefanya uamuzi tulisikizana kwamba uamuzi utakuwa unafanywa katika njia ile.
Huu mkutano mwenye sasa huyu wa chama cha ODM wewe mwenyewe haukuhudhuria huu mkutano. Kwa nini?
Kwa sababu za kiusalama.
Unajua hii maneno ungeweka mezani kuhusu chama kujiondoa kwenye muungano.
Kwanza mingi ya mikutano ambaye wamefanya hawa ndugu zetu wameipeleka nje ya Nairobi. Sijui kama mnajiuliza ni kwa nini mikutano hii haifanyiki Nairobi. Unajua wacha nikuelezee Gatonye. Na sisi ni wanasiasa na tumekuepo katika chama hiki kwa muda mrefu. Hawa ndugu zetu niliwaambia kwamba niliona pale Kilifi kwa mfano mkutano umepelekwa Kilifi katika eneo ambalo mtu anatarajia kwamba kuna usalama wa kutosha. Wakati ambapo wanaenda kusoma zile arafa zao tunasikia kwamba kuna watu ambao si wanachama wa Central Committee, vijana ambao wameletwa hususan kuweza kuwashambulia baadhi ya wale ambao wamekuja pale kwa ule mkutano. Na hizo yani wari zetu ambazo tulikuwepo kuhusu usalama, tuliweza kuzungumza na hawa ndugu zetu tukawauliza kwa nini iliwezekanaje kwamba hawa jamaa waweze kupata kuingia katika eneo kama hili. Pale si rahisi. Kumaanisha kwamba kuna mtu ambaye aliwapanga hawa vijana na akahakikisha kwamba wameweza kuingia katika venue ya mkutano. So hata kupeleka huu mwingine Mombasa, na mlisikia nyinyi wenyewe kwa sababu wewe ni practitioner wa media, unajua kitu inaitwa hot mic. Wakati mic iko on unasikia wale watu ambao wako hapa kando mambo ambayo wanayasema. Sisi sote tulisikia. Kwa sababu unajua tumefika mahali Gatonye wanatuambia kwamba tumeshinda debate zote. Maadili hatuwezi kushindana na wao kimaadili kwa sababu sisi ndio wenye kushikilia maadili ya chama. The law is on our side. Sheria iko pande wetu. Kwa mfano nimekuambia kama mahakama imetoa agizo kila mtu lazima afuate. Maono tuko naye. Mtazamo wa baba ni sisi tunaushikilia. Wanasema sasa imebaki vita vya ile physical sasa. Huyu Sifuna ni tumshike tumpige tu sasa. Manake wameshindwa kiakili, hawawezi kutuelezea tuelewe hizi decisions ambao wanachukua kwanza ziko na msingi katika maadili ya chama, ziko na msingi katika katiba ya chama, ziko na msingi katika maono ya Mheshimiwa Raila Odinga, hawawezi kukuelezea. Sasa imefika ni vita tu. Wanasema bahali tutamshika ni kumpiga tu. Kwa hivyo unaona wanaweka hii mikutano iwe ni kama ile trap. Kwamba ukija pale
ulikuwa umepangiwa, lakini
ndio hayo ndio nakwambia. Wanatupangia kila siku.
Ukapata kujua kabla.
Tunajua kwa sababu hawa vijana ambao wanawapanga si wanaondokea hapa Nairobi na ndugu zetu. Tumefanya nao kazi. Wanatuambia wao wenyewe Sifuna hapa umechorewa. Na tunachorewa kila mahali. Ndugu yangu Gatonye. Kakamega tunajaribu kwenda Kakamega wanatuchorea fujo. Nyinyi wenyewe mliona.
Actually tutakuja kwa hiyo.
Mliona.
Yes. Lakini ulikuwa umealikwa huu mkutano.
Mkutano wakati ambapo tunakubaliana kwamba kuna mkutano, arafa zinatumwa kwa kila mtu wanasema kuna mkutano. So si eti kwamba umekuchorea lazima ukualike.
Lakini mlikuwa na makubaliano ya kufanya huu mkutano kabla ya mkutano kufanyika, kwa sababu nasikia ni kama mlisema mkutano hautafanyika, watu wengine wakaenda State House usiku.
Mfumo ambao upo ni kwamba yule kinara wa chama kwa mfano vile Raila alivyokuwa akifanya, alikuwa yeye anasema kuna either mtu ameibua hoja fulani ama kuna haja ya kukutana. Kwanza mikutano ya chama ni kitu cha kawaida. Lakini mandhari ambayo mikutano hiyo inafanyika pia ni muhimu. Kwa mfano, iwapo kuna mandhari ambapo kuna mtu ambaye anahisi kwamba labda usalama wake utatishiwa, anaweza kuambia wacha tuweze kwa sababu unakumbuka kulikuwa na efforts fulani. Kuna watu ambao ni wazito katika chama walikuwa wametoa wito fulani kwamba hata kabla hizi formal meetings watu waweze kukutana faraga ili zile tofauti ambazo zipo katika uongozi ziweze kuwa ironed out. Na mkisha iron out hizo issues inakuwa rahisi kila mtu kuenda kwenye hii mikutano. Sasa ukiangalia yale mazungumzo ambayo yalikuwa yanafanyika nyuma ya tent chini ya uongozi wa wale ambao tunaita trustees wa chama, ilikuwa imewaomba kwamba wasitishe kwanza mikutano hii ili tuweze kufanya hii mikutano ya nyuma ya tent ambayo itapelekea kwanza joto kushuka chini, watu kuweza kusikizana, lakini wao walikataa, wakasema lazima mkutano huo uendelee. Na sasa unajua ni kwa nini walisisitiza kwamba mkutano uendelee? Manake plan ya huo mkutano ilikuwa ni kufurusha baadhi wetu. Unanielewa?
Chama kitakuwa na mkutano wa NDC nafikiria ni mwezi wa March. Utahudhuria huo mkutano?
Wacha niseme kwamba we will cross that bridge when we get there.
Kwa sababu kama ulikuwa umepangiwa wakati ule. Kwa ODM hapo awali tuliona kile kilikuwa kinaitwa Men in Black. Kwa nini?
Sasa wacha tuone,
na hii NDC ndio hata kubwa kuliko ile,
labda mandhari ambayo yatakuwa pale, kwa sababu tutatoa uamuzi wakati ambapo utakuwa mwafaka. Manake hamna cha kubishania hapa. Unajua pia maisha ni muhimu. Ukifika mahali ambapo unaona kwamba watu hawataki yani pigana kisera na kimawazo, wanataka kushika fimbo na panga, hamna haja ya kuvurugana.
Sasa mheshimiwa, ikifikia hapo, hata ikuwe wewe ni katibu mkuu wa chama na uwezi hata hudhuria NDC ya chama, itakuwaje? Kwa sababu watu wengine watajiuliza utaendeleaje kukua bado.
Kwa sababu wacha nikuelezee Gatonye, si lazima niwe katibu mkuu wa chama. Naweza kuwa mwanachama wa kawaida wa chama cha ODM. Nimekuambia kuna wanachama milioni 5 na wote wanaweza kufanya kazi ya katibu mkuu. Si lazima Sifuna akuzaliwa eti maisha yake yote yawe katibu mkuu wa chama. Mimi nimechangia katika kukua kwa chama hiki kwa muda wa miaka 9 hii. Huu ni mwaka wangu wa 9 nikiwa katibu wa chama. Kuna mambo mengi ambayo tumefanya pamoja kichama, na haiwezekani eti Sifuna pekee ndiye anaweza kukua katibu mkuu. Hiyo nakataa. Chama cha ODM kina talanta bana. Nakwambia kuna watu ambao wanaweza kufanya kazi. Hata mimi nilipopewa jukumu hili la kuwa katibu mkuu nilikuwa kijana mdogo sana, miaka 35. Kuna vijana wengi ndani ya chama ambao wakipewa fursa kama hii wanaweza kukua Sifuna wengine. Manake sio lazima iwe ni mimi. Mimi kile ambacho tunaomba tu ni kwamba sheria ya chama ifuatwe, katiba ya chama ifuatwe. Iwapo wataita mkutano ambao watasema kila mtu aje na nafasi zote ziwe wazi, kuanzia kwa kinara wa chama kwenda kwa katibu mkuu, niko radhi kubishana na mtu mwingine yote ambaye angependa kuwa katibu mkuu. Alafu wale wanachama wa ODM wakisema sasa Sifuna, tumetosheka na service yako kama katibu, tunataka uwe mwanachama wa kawaida ujenge chama katika nafasi hiyo, basi niko radhi kufanya hilo. Kile ambacho hatutaki ni hii mambo ya watu kupangiana fujo, kuleta delegates gushi. Unajua hiyo ndio vitu ambavyo tunasema tusipofuata katiba ya chama, basi tutaingia katika shida zaidi.
Wengine wamesema bali na kukutoa kama katibu mkuu hata watakufukuza kabisa utoke kwenye chama cha ODM.
Hamna shida. Unajua unaweza kufukuzwa, katiba inaruhusu hiyo. Unaweza kufukuzwa, lakini bora sheria ifuatwe. Lazima wawe na sababu za kukufukuza. Wawe na wafuate ile procedure nzuri, wakupe nafasi ya fursa.
Wakupe nafasi.
Tutajipanga, hakuna shida. Ukifurushwa kwenye chama umefurushwa. Hamna shida. Lakini kile ambacho nataka niseme ni kwamba hata hiyo kufurushwa lazima ifanywe kulingana na sheria. Isipofanywa kulingana na sheria, kutakuwa na shida zaidi ambayo tutaingia ndani kama chama.
Wadani wako wengine niliona hii kwa gazeti ya jana kama Mheshimiwa James Orengo, niliona akinukuliwa alikuwa anasema kiongozi wa chama Mheshimiwa Oburu Odinga ni kama hana uwezo kamili wa kuongoza chama cha ODM. Sijui kama hii ni kauli yako pia?
Hayo ni maoni ya Mheshimiwa James Orengo. Mimi jambo ambalo ninaweza kusema ni kwamba tumekuwa tukishinikiza kuwa ukiwa kiongozi utafute ile legitimacy ya wananchi. Nimekupa mfano kwamba maamuzi ambayo yalikuwa yanatolewa na Raila yalikuwa yanakubalika kiharaka na wanachama wa ODM kwa sababu alikuwa na ile legitimacy ya wananchi, alikuwa amepewa hiyo idhini na wananchi. So tulikuwa tunatoa haya mawaidha kwamba kabla tufanye uamuzi mzito, kwa mfano ni nani tutamuunga mkono mwaka 2027, kwa sababu katiba ya chama inasema kinara wa chama ataongoza mazungumzo hayo. Kabla uongozi haya mazungumzo, tulikuwa tunaomba kwamba tukupe hiyo yani tukufunike ama tukuvike lile vazi la legitimacy. Lakini kuna
katika uchaguzi wa chama,
kuna wale ambao walikuwa wanaona ni kwamba tuna challenge Mheshimiwa Oburu ama uongozi wake, ama tunataka kumuondoa, ama tumemkosea heshima. Unanielewa? Lakini hiyo haikuwa nia yetu. Nia yetu ni kutoa advice kama viongozi wa chama, nasema tunaweza kufanya hili na hili na hili, alafu tuweze kufaulu sisi sote kama chama.
Kwa hivyo kuna wengine walikataa
Wengine walikataa huu usemi. Wao wanasema tuendelee tu, ako na hiyo nguvu. Unajua amegeuka kutoka interim amekuwa substantive, wanasema yeye ndio yuko milele. Na kuna njia ambayo tunaweza kumove kutoka kwa acting kuingia kwa substantive kulingana na katiba ya chama. Wao wanasema si lazima ufuate hiyo mambo ya chama ya katiba.
Tuingilie mikutano yako ya Linda Mwananchi.
Naam.
Hii mkutano mheshimiwa, lengo hasa ni gani?
Lengo la hii mikutano ni kuhamasisha umma kwamba sio kila mtu ambaye anaimba huu wimbo wa two-term wa William Ruto. Kuna baadhi yetu, unajua kuna wale ambao wanasema watamuunga mkono, wanataka ionekane ni kana kwamba uamuzi huo umeafikiwa kijumla, kwamba sisi wote ambao tunaunga chama cha ODM ama wanachama wa ODM tumefanya huo uamuzi tayari. Wao wenyewe katika mkutano wao wa Mombasa ambao tumezungumzia, walisema kwamba chama kitafanya mazungumzo na mirengo yote ya kisiasa hapa Kenya. Lakini walipotoka pale wanakuja wanaanza kusema hawatazungumza na watu fulani, chama fulani, hapana. Haikuwepo katika zile resolutions. Na mimi ninavyoelewa, mkisema kwamba mtazungumza na kila mtu, inamaanisha mtazungumza na kila mtu, kisha mje mtupatie ripoti kama chama. Wanachama mseme tulizungumza na Gatonye, yeye anasema tutakuwa namna hii, mfumo fulani wa serikali kama huu, tutafanya haya na haya na haya tukiwa pamoja katika serikali. Alafu tukaenda tukamuona mwingine akatuambia yeye tutafanya hii na hii na hii na hii, kwa maoni yake tutaenda na hii. Alafu sisi kama wanachama tuamue ni njia gani bora zaidi. Lakini waliondoka kwenye huo mkutano wakaanza kuimba two-term tena. Unanielewa? Hapo hiyo confusion ndio inakuja, kwa sababu na sisi ambao tunaamini kwamba mazungumzo kati ya chama cha ODM na vyama vingine lazima yaongozwe na maadili ya chama na maadili ya kikatiba, tukaona kwamba sisi lazima tuwaelezee Wakenya kwamba maoni yetu ni tofauti, kwamba Gatonye haiwezi kuwa ukiketi unazungumza na chama kingine, mnazungumza tu juu ya nyadhifa. Ati wewe utakuwa waziri, huyu atakuwa PS, utanipea wizara gani, nani atasimamia fedha, nani atasimamia afya. Hayo sio mazungumzo ambayo sisi tunaonelea kwamba lazima yawe mbele. Yale mazungumzo ambayo tunataka, ndio kwa maana tunajiita Linda Mwananchi. Tunataka kuona mwananchi analindwa vipi katika mazungumzo haya, na serikali ambayo mnapanga kuiweka pale itamsaidia vipi mwananchi wa kawaida. Itamsaidia vipi kuhakikisha kwamba tunarudisha fedha katika mifuko ya wananchi. Tunawezaje kudeal na mambo ya ushuru? Ukiangalia payslip za watu siku hizi, hata mimi ninalipa ushuru. Ndugu yangu, watu wanaumia. Inakuwa vigumu sana watu kujipanga. Kwa mfano, unajua wewe, nikiwa kijana mdogo nilikuwa naishi kwa bedsitter pale South B. Nikapata kazi ya 40,000. Nikahamia Roysambu kwa 2 bedroom. Kwa sababu unajua sasa hii 40k ninaweza songa kulipa rent ya 6,000 kwa SQ, nilipe sasa 15,000 2 bedroom pale Roysambu. Unaona? Hii ni mwaka ya 2009. Sasa we niambie, iwapo hatuwezi kujua kama mshahara wangu utasalia vile ulivyo, utafanya maamuzi vipi? Kama ningehama niende Roysambu, alafu serikali iweke ushuru, wanachukua kwa hiyo 40,000 wachukue 20,000. Si ningerudi South B? Ningerudi South B. Inakuwa vigumu watu kugrow, na si ati kwa wale wafanyikazi peke yake. Hata mashirika kama haya K24. Kwa mfano, ushuru unalipwa na mwajiri na pia bado unalipwa na mwajiriwa. Kwa hivyo K24 kama inaweza kuafford kulipa Gatonye wawili, kwa mfano mmoja awe kwenye Kameme huko na mwingine afanye hapa, wanafuta mmoja, wanasema sasa Gatonye utafanya yote mbili vile unafanya saa hii. Unashikilia Kameme na unashikilia K24, sijui kama wanakulipa yote. Wasikie wakulipe ya Kameme na wakulipe hapa. Lakini mfano ambao unatoa ni kwamba shirika kama hili linafika mahali ambapo wanasema tunaweza waajiri wanahabari 5 peke yake. Hapo nyuma, kwa sababu tulikuwa tunaweza kujimudu, tulikuwa tunaweza kuandika watu 10. Kuna wakati ambapo K24 ilipoanza, nakumbuka walikuwa wanaandika waandishi wa habari watajika tena wengi, kwa sababu walikuwa na fedha za kutosha. Unajua fedha zinatoka wapi katika runinga kama hii? Makampuni ya mashirika ya kufanya advertising nini. Na kuambia mashirika hayo yakikata bajeti zao za advertising kwa sababu ya ushuru ya kasongo, na nyinyi pia mnaathirika. Sijui kama unanielewa. Kwa hivyo mazungumzo ambayo tunataka kuwa naye ni mazungumzo ya kimaadili. Nikae niulize huyu Gatonye, tangu kasongo achukue amepoteza pesa ngapi? Na tutamrudishia aje hiyo pesa? Unanielewa? Nikisha kulinda wewe, utanilinda mimi kama mwananchi. Haya matitle yote ambayo watu wanazungumza watamnyang'anya Sifuna, nyinyi mtanirudishia nikishawalinda. Unanielewa? Kwa hivyo hawa wanazungumza tofauti na sisi. Kwa hivyo mikutano yetu inapelekea kuambia Wakenya kwamba msikate tamaa, kwamba kuna uongozi mbadala, viongozi ambao wanaangalia mambo kitofauti sana.
Okay.
Viongozi ambao wanaweza kuhakikishia kwamba unajua nimesema wazi Gatonye, mtu yeyote anaweza kujenga barabara. Manake ukishachukua ushuru na wewe ndio rais, huo ushuru lazima ufanyie kazi. Kila mtu anaweza kujenga barabara. Okay. Mwana demokrasia atakujengea soko. Yes. Mwana demokrasia atakujengea stadium. Na pia madikteta wanajenga hivi vitu. Okay. Nimepeana mifano ukienda nchi zingine, sitaki kutaja nchi, unajua mabalozi wengine wanaanza kushika moto sana, wanasema Sifuna na taja. Lakini nyinyi wenyewe mnaona kuna mandhari fulani ambayo yamewekwa katika nchi za hapa Afrika Mashariki. Nchi zingine ambazo zina mabarabara juu ya mabarabara zinajengwa kama gorofa. Lakini ukisema ngwe ndani, sure. Uwezi kukaa chini katika kipindi cha mahojiano kama haya eti utoe maoni yako. Na unajua tulikuwa katika sera kama hiyo wakati wa utawala wa KANU. Mheshimiwa Daniel Moi ndio mwenye kutujengea Kasarani mwaka 1987. Yes. Yeye ndio mwenye kujenga Nyayo Stadium hii. Lakini ukiniuliza mimi kama nataka kurudi katika maisha ambayo tulikuwa tunaishi 1989, nani atakubali? Wakati ule kina Raila wako jela. Kwa sababu ya nini? Kupigania haki za kidemokrasia. Okay. So tunapozungumza na Wakenya wa kawaida, wanatuambia Sifuna, sisi tunataka kuwa huru. Tunataka kuwa huru katika nchi yetu, kwamba tunaweza kukutana pasi na kutupiwa vitoa machozi, eti mikutano inatibuliwa na vitoa machozi na polisi. Yes. Wanasema tunataka kuzungumza hapa kwenye social media. Si haitajiki kwamba nikisema Sifuna atupendi size ya mapua yake. Unajua sisi watu wa jamii ya Mlembe, mapua ni hii size. Sasa ati mtu akiandika kwa Twitter aseme Sifuna huyu mapua yake simpendi, anakamatwa. Wewe niambie, eti polisi wanaweza kuondoka Nairobi, waende mpaka Homa Bay, wachukue kijana huko wamlete hapa Central Police, wampige mpaka kumuua. Kwa sababu ya nini? Ati kitu ambacho amesema kwenye mtandao. Na sheria hii, katiba yetu hapa, nimeletewa katiba yangu, ilikuwa kwenye gari, inasema kwamba tuna hizi uhuru ya kuzungumza, kukutana, kuweza kubadilishana mawazo. So tunataka kurudisha nchi hii kwenye reli na zile vigezo vya maadili ambayo iko chini ya hii katiba, kwamba tulinde haki za kibinadamu, tuweze kuweka demokrasia, kuwe na uhuru wa vipindi kama hivi, watu kuzungumza, watu kukutana, tuweze kulinda uhuru wa mwananchi, tuweze kuweka utawala wa sheria ambao unapelekea kwamba iwapo kutakuwa na mzozo kati yangu na wewe Gatonye kuhusu kwa mfano shamba, tunaweza kuenda mahakamani. Mahakama isiwe mahakama ambayo inaweza kuhongwa ama kutoa uamuzi kulingana ni nani ndio mkubwa, na ile agizo la mahakama likitoka liseme shamba ni ya Gatonye, kila mtu ataheshimu, hata wakubwa wakiwemo. Haya,
kwanza twende upande mwingine tupate maoni ya watazamaji, wasikilizaji, lakini tukirudi, mheshimiwa, nani mfadhili wa hii mikutano yenu? Kwa sababu nimesikia baadhi ya viongozi wakisema Uhuru Kenyatta anawapatia pesa. Mwenzangu Brian, kwanza tupate maoni ya wananchi.
Gatonye, of course, let's take a look at what Kenyans are saying in regards to this conversation. And of course, the question we had asked was whether you support the Linda Mwananchi faction to front a presidential candidate or join the United Alternative Government, and also some of the questions that you have for the Secretary General of ODM, that is Edwin Sifuna. Well, Edwin Omolo says Linda Wananchi should fill a presidential candidate, and in case if they are joining United Opposition, let them join only if United Opposition will accept Sifuna as their presidential candidate. I don't know, SG, whether that is the bare minimum that you're willing to accept in regards to joining the United Opposition, only if you're given the opportunity to be the presidential candidate.
Is that a question?
No, I'm asking. He says that let them join only if United Opposition will accept Sifuna as their presidential candidate. Will that be a bare minimum for you?
First of all, the Linda Mwananchi group is not a party. It's not a political party. I don't understand why people are asking us to join other political formations. The United Opposition is a conglomeration of political parties. At least them, they are political parties. For us, we are not a political party. You understand? All right. So I don't know where these conversations originate, my brother. Yeah. Okay.
Let's get Justin Mugendi. Says, whatever they want, with or without them, we are still Sifunated. That is Justin Mugendi. Do you have one more? Paul Odongo says they have already joined United Opposition. Of course, this SG has said that they are not a political party. Grishon Masharia says filling their presidential candidate will be the best thing that they will do to Kenyans. It is the only card they should pull. Kingpin Jose Wayne says their big agenda is just broad-based government, nothing else. And Mwenda Edin says, join united opposition and take part in the forming the next government for Kenyans. Mark Maina says, the sooner Honorable Sifuna and Babu formed their own parties, the better. All right, I want us to listen to this bite because Honorable Sifuna had spoken about issues to do with, being attacked and also just his political, his rallies. People are organizing for him to be attacked. Let's listen into what happened in Migori yesterday, then come back, continue the conversation with Gikonyo.
Sisi ambayo tuko hapa Migori, hatutaki mtu aje hapa kutuchezea. Hiyo mrengo ingine ya wale wengine mtawaruhusu waje hapa Migori? Mmekataa? Hebu nione wale wamekataa kwa mkono, hebu sema umekataa. Wewe kama ni mtu wa kufanya ghasia, tafuta sehemu ingine ufanye hiyo ghasia. Hapa Migori kiongozi wetu ni Dr. Oburu Odinga na tuko kwa ODM kamili na tumeamua.
All right, that happened yesterday in Migori. Let me cross over to Gikonyo and of course SG. I don't know if you respond to that. Migori, to some extent, appears like a no-go zone for the Linda Mwananchi.
You see, first of all, Mama Ida gave us some advice. Okay. That in whatever circumstance, when you're faced with the difficult situation, ask yourself, what would Baba do? You know, Raila Amolo Odinga was our leader, and he faced similar things. I remember there was a time when there were places that we were being told Raila should not go and should not step. That is retrogressive politics. He himself was a victim of similar things. What we were saying is we want a country that is free. Okay. Any person who believes in democracy cannot utter such things. Let people come and canvass their issues. Let the country be open to everyone. Let everyone be able to go everywhere, because that is what the Constitution expects. Okay. When I told you, Gikonyo, when we started this show, is that we have won every argument. The law is on our side. The Constitution is on our side. The people are on our side. God is on our side. The DJ is on our side. You understand? Yes. So imefika mahali ambapo watu wameanza kusema sasa the only way ya kudeal na hawa watu ni kuwapiga. So ukisikia mtu anasema kwamba hatukubaliwi kwenda katika eneo fulani, hiyo ni siasa za kule nyuma ambapo ndio tunasema tumeondoka katika hiyo mandhari. Tunataka kusongesha nchi yetu mbele. Inahitajika huyo ndugu yangu ambaye amezungumza aweze kuja Bungoma, aweze kuja Kakamega, aweze kwenda Nyeri, aweze kwenda Mombasa, kwa sababu hiyo ndio demokrasia. Wacha wazungumze kitu ambacho wanataka kuzungumza na waondoke waende. Kwani mimi nikizungumze na kunyang'anya nini ba?
Actually, I'll come to that, Mheshimiwa. Kuna hii swali nimeandikiwa hapa na mtazamaji wetu, amesema ask Senator Sifuna what was the position of Oburu, what the position of Oburu Odinga was before Baba died, or he got party leadership because he's brother to the party owner. Tutakuja kwa hiyo. Turudi kwa leader Mwananchi. Naam. Mfadhili. Naam. Ni nani?
Kwanza Gikonyo, wacha nikupe straight answer. Yes. Sisi wenyewe ndio wenye kufadhili huo mkutano.
All the logistics.
Unajua lazima unieleze logistics unamaanisha nini? Manake nitakupa breakdown. Ndio nitakupa breakdown. Okay. Kwa mfano, nikitoka Nairobi kwenda Kitengela, nahitaji nini? Mafuta ya pesa ngapi? No, nieleze. Unajua na nyinyi kama waandishi wa habari, lazima mtusaidie kupambana na propaganda ambayo inaenezwa na hawa ndugu zetu. Mumecheza picha pale za mkutano wetu wa Kitengela. Mkutano tumefanya barabarani. So logistics ambayo unazungumzia ni hiyo gari imenibeba na sound.
Na jukwaa.
Na sound. Haya, jukwaa lile ambalo tulikuwa tumeweka jukwaa na jukwaa letu liliharibika. Yule ambaye anatupea haya majukwaa ni muandani wa karibu sana wa Mheshimiwa Raila Odinga. Walianza na yeye siku za Ford Kenya. Ni mtu ambaye anaamini katika cause ya mwananchi. Kwa hivyo yeye hata akinipa kitu, hanipi kitu kwa kunichaji ile commercial rates ambayo angechaji watu wengine. Okay. Total pesa ambayo tunampa huyu ndugu kutupatia sound na stage ni shilingi 1,500. 500,000. Tuko na zaidi ya wabunge 20 katika hili vuguvugu. Ma MCAs kibao. Wananchi wengine ambao wanajitolea kutupa support. Unaona kama Kakamega kwa mfano, tunaposema jukwaa ni shilingi 1,500. Inatugharimu chini ya, mimi personally ninatoa 50,000 shillings peke yake. Na tukiwa 20 hiyo ni shilingi milioni 1 kama ujue hesabu Gikonyo. Tumelipa jukwaa tayari. Okay. Na hiyo tu ndo tunahitaji. Ile truck ambayo uliona tukifanya nayo roadshow Kakamega nilipewa bure. na nataka baada ya hiki kipindi, kwa sababu sikutaka kumtaja huyo mfadhili, nitakuonyesha wewe arafa ambazo nimepokea kutoka kwa huyo ndugu. Akaniambia, Sifuna, niliona sound kidogo ilikulemea pale Kawangware na pia pale inaitwaje Kitengela, na niko na track imekaa tu kwa nyumba. By the way, do you know what, boss? When you put out a call to the people, you will be very surprised. People have these assets just sitting somewhere. Anasema ile kitu utafanya, utaweka branding tu, nipatie artwork yako nikuwekee branding. Na akalipa hiyo track. Nitakuonyesha. So huyo mtu ndio wanaita Uhuru Kenyatta. Hiyo si Uhuru. Huyo si Uhuru Kenyatta. Ni marafiki zetu, na nakwambia baada ya Wakenya kuona kwamba tunawalinda wao na tunazungumzia masuala yao, ile outpouring ya support ambayo tumepata, tuko overwhelmed ndugu yangu. Watu wanatuma fedha. Kuna student anasoma Australia, mwanafunzi bro, ananiwekea shilingi 50,000 hapa kwa M-Pesa ya simu yangu, ananiambia I am just a student, I can't do more than that. Tayari niko na 50,000 ni ile nitachanga ya mkutano wetu ya Mombasa wakati tutaenda. Kwa hivyo hiki kitu, unajua, nataka niwaambie haswa vijana, hiki kitu watu wanatakaga kuingiza vijana baridi ati siasa ni expensive. Siasa si expensive. Inategemea na goodwill ambayo mko naye. Sisi wenyewe sio matajiri, lakini nikikuuliza uniambie logistical breakdown ya mambo ambayo tunafanya, haipiti shilingi 1500 kupata stage na kupata sound. Nikupe tena, nitakuonyesha tena arafa nyingine. Kuna Mkenya mwingine aliniambia yeye rally zote ambazo tutafanya Western, ako na stage na ako na sound. Hizo arafa ziko hapa na atatupea bure. Unanielewa? Kwa hivyo haya mambo ambayo tunaambiwa hapa, ati hii pesa sijui inatoka wapi, hakuna. Kwanza fedha zenyewe tunaweza kuquantify, tuwaambie ni hii na hii na hii, na hivi ndio tulichangisha hizi fedha tukafikisha kiasi fulani cha pesa. Wakati ambapo tulikuwa tunaenda Kakamega, tulikuwa tumebook ndege za kawaida tu hizi kutoka JKIA twende Kisumu. Lakini usiku tukapata information ya kwamba kuna mtu mkubwa katika serikali, Ministry of Interior, amepanga vijana zaidi ya 500 eti wahakikishe kwamba hatutatoka katika kiwanja cha ndege cha Kisumu. Sasa usiku wa manane tunafanya uamuzi kama viongozi, tunasema sisi wana Kakamega wanatusubiri. Mkutano wetu lazima ufanyike, na kwa sababu hatutaki confrontation, tutafute njia mbadala. Tena tukaanza mchangisho hapo. Tukahitaji tena shilingi 1500 kukomboa ndege ya kibinafsi ituondoe katika mji wa Nairobi. Tukaenda kuland katika airport nyingine ambayo sio Kisumu, ili mkutano wetu uweze kufanyika. Tunaweza kuonyesha ni wapi fedha hizi zinatoka. Na kama mtu ambaye anaamini katika uwazi na maadili, tuko radhi kueleza Wakenya wakati ambapo tunatumia hizi fedha, ni wapi ambapo pesa hizi zinatoka.
Nimechanganyikiwa kidogo kwa sababu wengine katika serikali wanasema wako na intelligence wako na ripoti kamili kwamba Uhuru Kenyatta ndiye mfadhili, lakini umesema sivyo. Kwa hiyo
sasa unajua, kama mtu anasema ako na intelligence, akuonyeshe. Mimi Gatonye nataka kuhakikishia watazamaji wako na wasikilizaji wako wa radio, nitakuonyesha yule mfadhili aliyenipatia track. Nitakuonyesha, kwa sababu sitaki nimtangaze. Unajua hawa jamaa tunadili nao ni watu peti sana. Wakisikia Gatonye amenitumia Sifuna pesa, kesho wanakukujia wewe, wanasema wewe ndio unafadhili. Hao watu walinda mwananchi unaosikia wamekufuta kazi. They are very petty. So mimi sitaki kumtangaza huyu ndugu, lakini kwa heshima ya watazamaji wako, ili ujue kwamba sisi ni wa kweli, nitakuonyesha, na wewe utarudi hapa baadaye uwaambie kama nilikuwa nasema uongo ama ni kweli.
Mheshimiwa, I'm just thinking, najiuliza tu uhusiano wako na Rais mstaafu Uhuru Kenyatta ni uhusiano wa aina gani, kama kweli kuna uhusiano wowote?
Kwanza nataka niseme mimi namchukulia Mheshimiwa Uhuru Kenyatta kama rafiki yangu, kwa sababu ya ile kazi ambaye alimfanyia baba Raila Amolo Odinga. Mimi mtu yeyote ambaye alikuwa ni mfadhili ama mwandani ama mtu ambaye alimsupport baba kwa njia ambazo niliona Uhuru Kenyatta akimsupport baba, yani inafanya na waheshimu sana hawa ndugu zetu ambao walikuwa wanajaribu kumsaidia Raila aweze kufikia azma yake. Na mtazamo sawa na viongozi kama kina Kalonzo Musyoka, maana yeye pia amesacrifice sana position yake kila wakati kuweza kumuunga baba mkono. Mheshimiwa Uhuru Kenyatta alifanya mambo mengi sana ili kuweza kumsaidia Raila katika uchaguzi uliopita.